The appeal filed by the Karnataka Power Transmission Corporation Limited is partly allowed, and the review and judgment shall stand set aside. We find that there was no contract concluded within the meaning of Section 27(2) of the Act. The matter came back to the High Court for reconsidering points 3 and 4 accommodated by the High Court. The first responder shall pay to the appellant a sum of rupees 50 crores within 8 weeks. As regards further liability to pay, it will await and depend upon the decision of the High Court. So also the payment of rupees 50 crores by the first respondent under this judgment will be subject to the determination to be made by the High Court. The appeal filed by the Karnataka Electricity Regulatory Commission will stand allowed to the extent that the remarks made against it in the appeal judgment shall stand set aside as indicated herein before. Parties will bear their respective costs.
Deeply grateful, my lords.
I seek the indulgence.
Yes.
I seek the indulgence of this court to allow me to mention a matter. I am coming on behalf of Animal Welfare Board of India to get permission to file written submission for the matter listed before the Constitution Bench tomorrow. I may please be granted permission for the same.
How many pages is it?
It's 41 pages, 5 pages of submissions and annexures.
It is allowed. Yes.
Please,
Yeah.
and matters of this moment calls for deep application of mind, considerations, and the soul of thoughts which will fit with the level of debates. So I try to visit and revisit again and again, so that as far as assistance to the court is concerned, there's nothing is wanting. But few broad thoughts I thought I'll share with the Lordship before we get into the nitty-gritties of what
Tell us one thing only.
Your Lordship, please.
If we'll see 324(2), it says subject to the provisions of any law made by the Parliament. Subject to the provisions of any law made by the Parliament.
Your Lordship, please.
Our request is please take instructions and inform. Either there was no necessity to frame any law on the subject, or it was never brought to notice that some law is required for the purpose of implementing clause 2,
Your Lordship, please.
which calls upon the authorities to make an appointment to the Chief Election Commission.
Right.
Because we are now 76 years down the line.
Your Lordship's right.
And merely because somebody knocks the doors of this court and call upon to examine the issue, then only you come out and say that we'll examine as to what is to be done on our part. And why your obligation cast by the constitution makers has not been so far acted upon.
I will try to address that question. And
because the judgment which you are citing, Vineet Narayan and all, there was no legislation, and this court thought some legislation is required on the subject. For which the Parliament, in the ordinary course of business, has to take a call. Anyhow, as per the social structure changes, law also required to be.
Absolutely, no doubt about it.
But in this peculiar matter, there was already an obligation by the constitution makers put on that please make the law on the subject for proper implementation and if giving effect to 324(2) by making an appointment.
There's one way of looking at whether the Constitution itself casts an obligation. And the question arises at what point of time?
What is your stand?
What will
You
be
say
the-
you are not required?
No, I'll address that question. I first
No, straight away.
lay down.
According to you, is not required, or if the court will call upon, you will go ahead.
No, either way, I don't think this question, with great respect, can be answered either or way. So let me try to explain why I take that stand, and then presently probably depending upon the discussions we have in this matter, I may try to proceed further.
All right.
Now, let me try to, because this issue, like in several other earlier situations cited before the court, are broadly built on principles of a vacuum or a silence or a gap. Way back in 1948, Michael Foley's book on the silence of constitutions has been the subject of some discussion at some point of time. Before I take your lordship into that, I just want to reflect on how one may look at that. Under that very inviting literature by Professor Lawrence Tribe on the Invisible Constitution again, has also triggered a lot of debates both in US and outside. So today, we are certainly, while talking about and expounding the Constitution, ever since you just Marshall talked about it. One important thing which comes to your mind while screening the whole developments taking place in the past 2-3 decades across the globe in different constitutional courts, post-World War, importance of human rights, and ensuring that fundamental rights get their best possible comprehension and understanding, protection, promotion, etc. So almost across courts in Asia, courts in Europe, there is some movement towards ensuring that the courts play an important role. So therefore, today we have a lot of literature which say constitutional courts as mediators, constitutional court as positive lawmakers. So we have all those interesting literature which scans the role played by the constitutional courts across the world. But besides all that, while all that is very important, because if the courts do not play a role, then perhaps if the salt lose salt, who else will do it? That's how it is. But while it is said so, some fundamental principles will also be always kept in mind. I mean, I am not going back to a doctrinaire Montesquieuian theory of separation of powers. I think that is a line. That's a line which the court will move very wisely from time to time. Where it is needed, well, move it wisely. Where it is not needed, the deference principle will certainly apply. And when I say that, I don't say the deference principle will be mechanically applied with a closed mind merely because the state calls for a deference. Just as you said, we are expounding the Constitution at a given point of time. Very simple example in any book on interpretations I choose, the word telegraph. So it did not contemplate telephone. So you said telephone would be included in telegraph. Many pedestrian examples. So when you come to a constitutional meaning, of course, they stand at a very higher level. Some commentators say the constitutional courts are not merely adjudicating. Adjudication relates to pleadings, proof, evidence, evaluation of evidence, etc. We slightly stand on a different level. That's why some people prefer to use deliberation. Again, after the Canadian Charter, people began to write on the deliberations as the interplay between the court and the state. So these are all theories which have now grown around the role of the constitutional courts. But what would probably come to the court's mind at any given instance is, how do we really merge them all together and have a manageable standard which the court will be able to deal with. And then is a demand from the state that you have an obligation which is clearly visible either from the plain reading of a statute or a constitutional provision. And I don't find any explanation why the obligation has not been discharged. And therefore, we call an explanation from you and find out how it can be taken further. Or where that obligation is not cast in so many, plain words. Sometimes the court may not try to read an obligation into it, except, for instance, like the Julius versus Bishop of Oxford, power coupled with duty. So in all those circumstances, the court will say, is there really an obligation? And if there's an obligation, which Constitution contemplates, what kind of an obligation it is, when will it be triggered, at the trigger point being reached, or if it has not been reached, then how will the court look at it? I thought I'll just flag all these broad statements and propositions before I come to 324. So let me just quickly take your lordships through this. And before that, I was.
Mr. Attorney, you accept that court has a role to play in cases where there are, okay, I wouldn't call it, we would call it gaps. There are scope of interpretation of constitutional provisions as regards obligation of the state.
Yes, let me only.
So jurisdiction of the court you are accepting.
Correct. Let me only.
Now we are
yes.
discussing only the contours or the outer limit of that jurisdiction in the facts of the given case.
Right. I just want to qualify this gaps and silences theory. I'll come to it a little later. I'm going to expound on that.
One more thing,
Your Lordship.
you must have realized the obligation. But for that, now where is the question of constituting a committee, that is Goswami committee? So having constituted it based on a meeting which was held on 9/1/19,
No.
that was constituted for this purpose, to study. So you know that an obligation is there. Committee was constituted.
I'll try to respond to this question.
Have a study on.
I'll try to respond to this question. Let me go in some, I'll make a note of each one of the questions and come in a seriatim.
Yes.
Attorney General, I just wanted to
Your Lordship.
bring two aspects.
Your Lordship.
Thanks to Wikipedia over the weekend, we just keep this. Just a phenomenon which I wanted to elicit your. You'll give a copy to. One copy to this. If just keep that's for all of you together. It's just what we just sort of found out a little bit of sort of statistics. Now, the first the chief election commissioner was Sukumar Singh.
Yes, sir.
Now he was, of course, a civil servant. Now the total period, Ashok Sen, in fact, brother of Ashok Sen, a distinguished lawyer. Now the total period that he had was 8 years and 273 days. And the next one was incidentally the first law secretary, KVK Sundaram. He had 8 years and 284 days. Now, he was a very distinguished man, principal author of the white paper, which was used to guide India into states. Then came SP Sen Verma. We don't have information, but he had nearly 4 years. I think it's about 4 years. Then came Dr. Nagendra Singh, I mean, known to us, who became
ICJ
president.
ICJ.
And he had, of course, 128 days, but that is the shortest you will find in the 50s and 60s. Then you had T. Swaminathan. Again, he had 4 years and 10 days. He was a member of the civil service, cabinet secretary. Then you had Shakta. He was Secretary General of 3rd Lok Sabha. I don't know whether he was a civil servant, but I think he was a very distinguished, because he wrote the book on parliamentary
Sure, yes,
procedures.
yes.
Very distinguished author. And then we had R.K. Trivedi, he was a civil servant, but he also had 3 years. Then we had R.V.S. Peri Shastri.
A very distinguished academician.
Very distinguished academician. We'll come to it as we turn. Now things
Yes.
turn out, He had 4 years and 4 months. He started his career as a teacher, I believe. We don't know whether he was a member of the Law Commission.
He was.
And then we had this temporary blip, if I may call it. We as Ramadevi. She was a politician.
I think she became a governor.
She was a governor,
Governor.
and then she became a
That's-
AC member.
That's right.
Her tenure was very short-lived. She was 69 days. Then you had, of course, T.N. Seshan, who took over on the 11th of December, 12th of December 1990, lasted till 11th of December 1996. And we don't have to say about him. I was obviously sort
That's-
of.
I just want to correct your lordships on one small thing.
Ah.
Ms. Ramadevi was law secretary, union law secretary. So I don't think
she was a civil servant.
well, union law secretary is
For
what
some
the
time.
book co-authored by her says.
For some-
Was he
Yes,
a
yes, he
civil
was.
servant?
I'm
Just
not
take up
sure about
Book on election laws.
Yes, book on election.
Just find
Like
out whether she was a
Vendirata
civil
and-
servant, because Wikipedia can also be. sort of-
Yes, yes.
The credit goes to Wikipedia. But we wanted to this for another purpose, and that's going to come.
I mean,
Yes, yes.
And that's going to come now.
please.
MS Gill, he had 4 years, and that is 96. Now, please mark from now onwards. That is from 2007 February 2004. Journey begins when the longest period is hovering around 2 years.
Yes.
You'll see 2 years. Lindo had 2 years. He was a civil servant.
269
P.S. Krishnamurthy, he had 1 year and 69 days. B.B. Tandon had 269 days. M. Gopala Swami, he had.
He was there for quite some time.
He was there
With the
3
Home
years.
Secretary.
He was there for 3 years.
I
He was there for 3 years. Then we had Naveen Chawla. He had 1 year, 89 days. Qureshi, 1 year, and I think 369 days. But 2 years, nearly 2 years, all 2 years. Now, V.S. Sampath again, 2 years. H.S. Brahma, I think it's 92 days. Then over the page, Naseem Zaidi, again 2 years. Anshul Kumar Jyoti, he had 200 days. Om Prakash Rawat had 312 days, less than a year, all less than a year. Sunil Arora, he had 2 years and 131 days. Sushil Chandra had 1 year and 31 days. Rajiv Kumar had 188 days. That is less than a year.
Yes.
Correct? And of course, we have the latest is Arun
Yes.
Goel, but we don't know about him.
Right.
The question is this.
Yes.
You see, under the 1991 Act, the term
Give the right.
of the Chief Election Commissioner is to be 6 years.
Or 65.
It is hedged in with a limitation following from the proviso, which says, provided, however, if he attains the age of 65 prior to the expiry of 6 years, that his term will come to an end.
Yes.
Correct? Now, what we are trying to point out to you, and we expect an answer from you, because
Yes.
this is a very, very, very disturbing trend,
Yes.
which is this, that after 2004 particularly, the slide has begun in terms of picking up those persons whom, of course, the government knows the date of birth. They know that they will never ever get anywhere near close to 6 years.
Yes.
So the term is a very highly truncated one, known from the very beginning. So in this way, this so-called independence that you sort of pay lip service to, I'm sorry for saying that,
Yes.
is completely destroyed by having this kind of a term. See, for anybody at the helm of affairs of an institution, one of the most important things is the time he gets to, do what he wants to do. So you are actually, all this happens because it is relevant how it is connected.
I see.
The appointment process is how you carry out the appointment process. Then if you have a procedure, because You have, of course, the first proviso, as far as the
Yes.
Chief Election Commissioner is concerned, to Article 324(5), which says that you can't be removed except on impeachment.
That's right.
And secondly, his conditions cannot be varied except, not
That's
to
right.
disadvantage. It's
That's
a constitutional protection. But this is a protection which you can avail of, provided you have a term. Now, your term is 188 days, your term is 160. I mean, this is a trend from 2004. Be it the UPA government or be it, so I did a little maths there also. And I found that, when it is from 2004 to 2012, we take it, for 6 years, 6 chief election commissioners for a period of 8 years. Now, 6 into 6 will be 36. That is one math. The other math is, for the period after the present government took over, that is 2015 to 2022, for 7 years, you have had 8 chief election commissioners.
Actually, one of the reasons why this is
Hi.
happening is that I'll tell your lordship what is happening.
No, whatever is happening, we are telling you.
Something very relevant.
This
Something
is,
very relevant.
This is
I
something
know.
which we have to factor in when the discussion takes
Yes, yes.
I look at the broader.
What they have done, my lord, what they have done after the Thursday hearing.
We know that.
Thursday hearing, I
We
mentioned.
know that. We know that. We
They
know
have
that.
hurriedly appointed a third election commissioner
seen
between
that.
Thursday and today.
We have seen that.
And-
We are conscious.
No,
And
don't say
that-
hurriedly appointed.
But this is this is statistics which cannot be wished away, which stares at our faces, which we'll have to factor in when we, take a view either way,
I understand that. I'm not.
which we are placing right
I,
at
I'm,
the
so,
beginning
I'm,
of your
I'm
answer.
so glad you lordship has put it to me. And I,
Now, the second aspect
yes.
is, again, we just sort of we'll give you. These are some of the laws, relating to election commission. And we thought that, we have to look closer in our neighborhood as well. We are going to England. We thought we should start with Sri Lanka, for example. And so sorry,
No, your lordship, I don't.
we have
We-
made a,
Yes.
we just expect that you will give it back to us.
Yeah, we do.
Little nicerly.
And also occasion to look in
The
the
government property so that we.
No.
So we got one more actually, we can just. So what we've done is, if you see the first is Sri Lanka,
Other countries. Sri Lanka.
it says, sub-article 3, it's incorporated in the constitution, article 103, sub-article 3. They go as far as, prohibiting, no person shall be appointed as a member of the commission or continue to hold as a member if he is or become a member of the parliament, provincial economy, local authority, or is appointed as a judicial officer or a public officer. Okay, that is one thing. Then you have Nepal. See how far they have gone. They say that at 245(2), the president shall, on the recommendation of the Constitutional Council, appoint the chief election commissioner and the election commission. So they have made that. Now let's go over to Bangladesh. There, of course, it is closely, they have this almost same subject to provision. I think this is modeled on our constitution, and certain restrictions are there. If you can skip it. Now let's move over to Pakistan. You see how they have structured it in terms of the criteria for appointment. No person shall be appointed commissioner unless he has been a judge of the Supreme Court, or has been a senior civil servant, or is a technocrat and is not more than 68 years. Now, they have taken pains to also articulate what is meant by a senior civil servant, a technocrat, etc. And then the Prime Minister shall, in consultation with the leader of the opposition in the National Assembly, forward 3 names for appointment to the commissioner to a parliamentary committee for hearing and confirmation of any one person. And various provisions are there which we sort of commend for your consideration. Now, if you come to the next one, you'll find
UK.
UK. That is another model you'll get there. And if you come to the US, the last one, the Federal Election Commission, so it goes in for the Senate confirmation. And there you see at 3, Arabic 3, members shall be chosen on the basis of their experience, integrity, impartiality, good judgment, and member, etc., etc. And various other restrictions are put. So we just thought that we should place this for your consideration. You want us to remain behind other countries, particularly having regard to the disturbing trend we found. How it has become a license, how they think there are no checks and balances. Nobody can question them because there is no law. There is nothing is like you said, we are talking about the silences of the Constitution.
I see that.
How the silences of the Constitution are being exploited. There is no law. Like you said, there is no law, there is no check. Nothing can be done. Legally, yes, they are right.
I think this first blush, having seen these, every one of these constitutions mentions mandatory using the term of the Chief Election Commissioner and Election Commissioner. It also provides for removal to be on par for both the CEC as well as the Election Commissioner. I just saw it. We're very grateful for this level of research done, which we could have done.
Not on the lexical meaning of may or shall. It depends on the context in which it is used, and then how an authority perceives the nature of the duty. Therefore, we did not go on those lines. I've also seen many of these. You
would have seen it.
Many of this
constitution. Wanted to just place it.
And for instance, the Canadian electoral reform.
That's right.
The Constituent Assembly had looked into that. So, at some broad and except this very detailed, I've also
one more last observation so that you can just think of it when you reply. See, in the Constituent Assembly debate, you notice actually the tide was turned by the member from Bombay. What's his name? I forget the name. He would say that the Election Commission is contemplated as an agent, as a part of the government.
Correct.
And what is his name?
I'll just pick it up.
Munshi came in. So Professor Munshi remarks, he said, let there be a law, let it be worked out. And it can be a part of the government. It should not be divorced entirely. It can't be given independence because all the resources are being provided by the state. So it is necessarily dependent upon the state.
Yes.
It cannot have an independent role. He goes to even say it cannot become a super government.
Yes.
So those, the point is at the time when the founding fathers, because when you talk about expounding the Constitution, as you know, there are 4 theories.
Right.
Which the US Constitution, the originalist theory, which is what the founding fathers had in their minds at that time. And, future generations are hidebound, they can't go behind it.
Yes.
Whether we should stick to the originalist theory, which is what some judges in the US Supreme Court, advocate, but whether we should do that in conditions peculiar to our country and knowing how things are, power when it is obtained, how it is used.
I know there'll always
2004 to 2020, I've given you statistics.
Yeah, absolutely. There'll always be a perspective from that point of view.
That's right. We have to deal with our conditions.
That's right.
Our men.
That's right. And while we enter into that,
sorry, we have taken.
No, certainly. I'm extremely grateful for inviting me. And I've also done some little exercise, but not fully, as your lordships have done. I called for some information and then looked into it. And one may throw some light on it. After probably I'll get some more instructions on it. How to help
go ahead.
But before I broadly looking at pre-1991 and post-1991, can be broadly classified. Why it might have happened like this is too difficult to guess. But then probably one has to dig into the archives, what happened 8 years, long years. But now that the law is there after 1991, how do you go about working under the law 6 years? Whether it is obligatory, can you curtail it? Will you not look into it more closely and say, yes, I am bound by it? All those questions are very important. And certainly one cannot shy away from those questions. Yeah, I'll try to, but broadly speaking, when I looked into this, my first question was, what is the position in other countries? So I tried to look into it. If the constitutions in other countries, if the constitutions themselves proceeded on certain lines, then we are talking about a constitutional scheme. So a comparison between two constitutional schemes may or may not be too appropriate, except where distinct constitutional schemes notwithstanding, the working under these constitutional schemes are given some lessons, useful, which can be borrowed. That's how I look at it. But instead of getting into those very narrow dividing lines. But if the Constitution of India says 324B shall be like this, and it also provides a certain understanding that over a period of time, whenever the time may come, Parliament may enact a law to deal with certain matters or subjects under 324B 1, 2, 3, etc. Then the question that may arise for consideration is whether the Parliament has done something under the Constitution is one question. Whether the other parts of 324 1 to be the place of the President, how the President will exercise her or his discretion, pointing, so and so, they are parts of the Constitution. It is one well-settled principle that an original provision of the Constitution cannot be put to challenge. And Violation Prashant Bhushan in his submission says, declare the appointment procedure as unconstitutional. Court will not do that. An amendment to the Constitution because of 368 powers, all those basic structure, of course, that will certainly be a matter for consideration. Therefore, a very important distinction in the original provision of the Constitution, as it stands, the court will not strike it down. But where it becomes necessary, that's why in the context of fundamental rights, well, let me put it like this. We keep saying fundamental rights are an integral part of the Constitution. Part 3 and Part 4 are the two chariots, wheels of the chariot and the constraint, etc. But I suppose if fundamental rights permeate the entire constitutional scheme, let us proceed on that footing, so that we have a very comprehensive view of the Constitution itself. Today, courtesy after 1978, state of Karnataka, Rajasthan, although Bommai has taken the leap forward. And thereafter, even in Article 311C, the President's decision-making process in respect of armed forces can also be subject to scrutiny. So what are those matters that are open to scrutiny are all on the basis of fundamental rights and certain scheme of the Constitution which will advance the fair movement of the Constitution towards a higher social order. That's how one can look at it. But that would again not mean that by process of interpretation or a meaning given to words in the Constitution, one can enhance the quality of the working of the Constitution, raise it to higher levels of working. That is done. But to come back if the original provision of a Constitution has certain issues, then will it not be a matter for a parliamentary debate? Will not be a matter for a broader social democratic debate as to whether this provision should remain as it is? So that line of distinction, I think, is very important. So that's why I would like to answer both these questions a little later. Now, I was reading a book on administrative law in US. A very interesting observation made. I've tried to read it and then go further with my silence of the Constitution. Yes. This is how the author puts it. I've tried to kind of paraphrase it. The subtle problems of modern policy making are more akin to automobile design. I'll take a printout and give it out. The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. It's not that. No, I'm not reading. I'm just reading it from my hand. I'll just give it to you. I'll just hand it over.
What is the nature of what is the book?
It's a administrative law by Christopher Redley. I'll hand it over.
Administrative law by. What is the name of the author? Just give us the name of the author, that's all. By Christopher
Edley.
Edley.
I thought I was paraphrasing from that particular page.
Italy. Yeah.
The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. The artistry is in the complete vision and in the integration of subsidiary skills. No, no natural law assures us that a collection of skilled musicians will produce beautiful music. And no natural law of management assures us that a collection of experts will produce worthy administration. That's where all these problems arise. The whole is neither more nor less than the sum of the parts. But why I wanted to read it out is that we are looking at the design of the Constitution in certain parts where we think, is there something originally lacking in the vision, or it was not the original lack of the vision, but a later point of time in the understanding of the importance of the latent designs in the vision, and therefore there is something which is deficient in the understanding and the working of the Constitution. So if you're looking at the later part, deficiencies and in the understanding and the working of the Constitution, and therefore there is something which is wanting. That's why we all entered in the question of a vacuum gap and things like that. Probably I would like to pose a larger question. Apropos what this poster told me. We will take your lordship from Vineet Narayan onwards. And these are all areas where we are concerned with either the realization of fundamental rights have some issue, or there's some disability imposed, or the infringement is indirect. So on and so forth. One can probably multiply how, in the context of realization of fundamental rights, there is an issue. And that the court, therefore, is anxiety and concern to ensure, as a sentinel and the qui that fundamental rights shall anyway, in any manner whatsoever impediment, obstacles shall be removed and shall be facilitated, realization made possible. It's in those areas where, not that the court would imagine a vacuum, but there is an actual concrete situation when the court comprehends and says, yes, let me look at it and how do we handle the situation. Therefore, there's always a gap between in law and life. Holmes' famous statement is logic, experience, but Chief Justice Israel Barak and said, no, it is both. It's both logic and experience. I think that's correct. So that's why you're talking about the experience and also the logic behind it. But having said that, let me just take a quickly and then go back to mine. This book was written in the context of the unwritten Constitution of England. There are a lot of constitutional conventions which occupied parliamentary debates and how courts would look at you also come to page 10 of this. There is just the second paragraph. Abeyance should not be thought of. Page 10. Abeyance should not be thought of as empty constitutional gaps to be filled in through the normal course of legal interpretation and political development. Neither should they be seen as constitutional deals by which particular issues are attended through through a conscious form of mutual accommodation between contending parties, nor as conventions demarcating expected behavior through informal but generally obligatory agreements. On the contrary, abeyance should be seen as akin to barely sensed disjunction lodged so deeply within Constitution that far from being susceptible to orderly compromise, they can only be assimilated by an intuitive social acquiescence in the incompleteness of a constitution, by a common reluctance to press the logic of arguments and political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. 3 or 4 thoughts which are suggested here. The last part of it is that by a common reluctance to press the logic of argument on political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. That's why we go back to the original constitution and we look at it as something which is taken, which is given. So it's one thing to say what the constitution says, and it's a different thing to say what the constitution means. And what the constitution means will often happen when the court is called upon to engage on, most importantly, on the rights of people. While it's certainly an important value in itself that an independent election authority is a fulcrum for free and fair elections, citizens' participation in a free and fair election, the enabling element, etc., all that is well taken. I don't think we need to have any debate on that at all. But in what context the court will be called upon to say, what is that you have failed to perceive? That's the only question that's being presented. I have a 2-part note which I have prepared. I think it's been handed over to your lordships. I have been very ably assisted by Mr. Balbir Singh. We had a lot of useful insights. We had good discussions. I'm sure he will continue to assist your lordship in the best of his capacity. Before I read this note, and it's important that I try to come back on the instances of appointment, the durations, etc. I'll try to come back on that. Preferably if I get some factual data, I'll try to come back on that. I think it will be very useful for the court and may I just read a few parts of this part 1 of the submission. Paragraph Roman 2 at page 2. The concerns raised by the petitioners were debated in the Constituent Assembly, which finally approved 324 as it stands today. In the Constituent Assembly debates, Dr. B.R. Ambedkar submitted with regard to the appointment of Chief Election Commissioner and Election Commission. There are 2 alternatives before the drafting committee. You have a permanent body with 4 or 5 election commissioners that will be making the commission a permanent body, would continue in office throughout without any break, or to confer powers on the president to appoint ad hoc body when the election will be handled. Or the 2 proposals consider the drafting committee steered a middle course to have permanently in office and of a chief election commissioner, leaving the conditions of the tenure and further appointments of any other election commissioner the will of the president. On the tenure of the election commissioners being made fixed and secure, Article 2, Section 2 of the US Constitution is considered, whereby certain appointments that specified therein cannot be made by the president without concurrence from the Senate. Dr. Ambedkar submitted the American practice a very dilatory process are likely to create administrative difficulties. Then, therefore, that's an important pointer to be kept in mind. If the other examples already before the Constituent Assembly, and those examples did not persuade the constitution makers to adopt them, either in the unmodified or any modified form, then probably the court will say that what way to the Constituent Assembly will have a certain amount of consideration and deference. It's one thing to say when you're debating in the parliament that what are the schemes would better serve the current needs of a society. And those parliamentary debates may travel or cover a wide range of concerns, issues, and data, whatever different political parties may come to fore in the parliamentary debates. So when therefore the Constitution as it originally enacted says, I take this course, at a very extreme point of view, I'm not, may not be seen as saying that there are certain insurmountable obstruction to the court navigating or steering constitutional surveys. I'm not saying that at all. But the extreme point of view, if the court were to say, we have some disagreements today on what the original Constituent Assembly thought about. And the disagreement may come in only in the context of experience. Experience saying that the independence of an electoral body has been mortgaged, either in the appointment process or in the removal process or in terms of conditions of service. See, if that experience is not very clearly delineated, I understand these instances may throw some light on that experience. I'm not shying away from that. But they must be so appealing enough and so disturbing the conscience of the nation and more particularly the court that this experience tells us that probably we need to have a relook, a second look as they call it. But what will the court then do? So will the court say, we have on deliberations in the course of engagement with counsel and parties, assistance of parties, etc., we think that this would be a more suitable course of action. That can be a problematic issue at some point of time. Why I want to say that, I'll come to it a little later. Because we are not now talking about a standalone provision in the Constitution, a standalone isolated instance where the court may take a view, and maybe it's the most appropriate view to be taken. And therefore, it doesn't become a precedent issue at a later point of time. But when the court may proceed to issues on a certain constitutional deliberative basis, say that this is what the government should do or the parliament may do. So I look at the various provisions of the Constitution where the Constitution has provided for an obligation or a duty or the parliamentary intervention at some point of time without indicating at when they will do it. So I have a large number of several instances in the Constitution where parliamentary intervention is proposed and suggested. So this may not become an isolated one-off instance, and therefore what the court may do, whatever little or minimal or whatever the court may do, may have some implications on the other aspects of Constitution where the parliamentary intervention is found desirable. I'm only looking at it from that point of view. I'm not even saying because of that you will not do that, but that will be kept in mind by the court. That will be a very important caution that the court will keep in mind.
Yeah. Yeah.
The provision of the Constitution will take only to speak at least. Stick to the court. Part 2 of the note.
Yeah.
The part of the note dealing with the concept of vacuum.
Part 2 of the note.
And there is an annexure A to that note.
Interfere.
Yeah. Yeah, we got it.
So I try to enumerate those other provisions of the Constitution where parliamentary intervention is looked at. Of course, the context may differ. There is some could be variations in the need, but just I've enumerated them. For instance, we have Article 10. Every person who is or deemed to be a citizen of India and any of the foregoing provisions of the part shall, subject to the provisions of any laws made Parliament, continue to be such citizen. Okay, there are many provisions where Parliament has enacted laws. So those are laws I'll try to point out where the need, the necessity, the urgency, which are probably built into the provisions themselves, is perceived by Parliament, and Parliament is proceeded to enact legislations. So therefore, it all depends on one, the context where parliamentary intervention is envisioned, and the need or the necessity is also felt by the Parliament. Parliament is enacted thereafter. So citizenship is a very important aspect of the Constitution. It must require parliamentary attention. Now, the Secretariat of Parliament, 98(2). Parliament may by law regulate the recruitment and conditions of service of persons appointed in Secretary of the Office of the Parliament. Until provisions made Parliament in a clause, so the President may, after consultation so and so, make rules regulating the recruitment conditions of service to the Secretary of Staff, the House of the People, etc. Therefore, there are rules which have been made under 98(3). We skip then Article 137.
You are not for a moment suggesting to us that members of the Secretary to the Parliament are to be compared with Chief Election Commission.
No, I'm not such. I'm not such. No, certainly, I'm not suggesting.
I mean, whether
I'm
you
only
make a
looking at.
law,
No,
whether
no,
you
please
make a
don't
law,
mistake.
whether you make
Certainly,
a-
I'm not doing that at all.
all.
I'm certainly not. I'm only trying to enumerate those provisions where
We follow.
Parliament law.
It's very useful because
That's all.
we get it sort of one.
Then again, 137. Subject to the provisions of the law made by Parliament or any rules made in the Article 145. The Supreme Court shall have the power to review any judgment.
Just one.
I'm sorry, not just both of course.
Yes.
What I will do along with this, I'll give an additional note where Parliament either made rules or provisions or law. So that will supplement. That's right. So we don't have any parliamentary law as far as the 137 part is concerned. That's been entirely regulated by rules made under 145. But the Constitution equates parliamentary law to a rules made under 145 or rules made under 145. They are more or less placed in the same footing. Subject to the provisions of any law made by Parliament or any rules made in Article 145. So therefore, if the rule in 145, unless the Parliament thought that there is something more to be done by the Parliament, Parliament would have enacted. If they are sufficient enough to deal with the matter, and therefore, having regard to the high position the Chief Justice occupies in the consultative process, the Supreme Court employs welfare case thereafter. Then 142, Clause 2, subject to the provisions of any law made in this behalf by the Parliament, Supreme Court shall so and so all and every power to make any order for the purpose of securing the attendance, etc. There is no law as such on this subject. Again, Article 145. Subject to the provisions of any law made by Parliament, Supreme Court may from time to time, the approval of the President make rules. So by and large, only rules made by Supreme Court under 145, there is no law made by the Parliament. Then again, 146, we have Clause 2, subject to the provisions of any law made by Parliament, the conditions of service so shall be prescribed by Chief Justice and the rules. Again, the same position, there is no law except the question of pay, condition, service of Supreme Court employees came before this court on comparison with condition, service of High Court employees. And that's how the Supreme Court employee judgment came. Then 148, the salary and other conditions service of the Controller and Auditor General shall be such as we determine by Parliament by law, shall be as specified in the second schedule. Again, subject to the provisions of the Constitution and the law made by Parliament, conditions of service, etc., shall be such as to be prescribed by rules made by the President after consultation with the Controller and Auditor General. We have rules. I may then come to Article 243K. Subject to the provisions of any law made by the legislature of a state, the conditions of service and tenure of so and so shall be such as the governor made by rule determined. Therefore, the rules made by the governor in these regards. In Article 300, Government of India may sue or be sued by the name of the union and government of the state, etc., subject to any provision be made by Act of Parliament or the legislature of a state enacted by virtue of the powers conferred of the Constitution. Sue or sued in relation to respective affairs in like case of the Dominion of India and the corresponding province, the corresponding Indian state, etc. And is often cited for the purpose of vicarious liability of the state and constitutional torts and so on and so forth. Then we have all these provisions, Article 338, National Commission for Scheduled Castes, and 338A, National Commission for Scheduled Tribes and Backward Classes. They're all constitutional provisions, and every one of them, each and every one of this provision talked about subject to provisions of law made by Parliament. And there are parliamentary legislations regarding their terms of appointment and who shall be appointed. Therefore, there are instances in Parliament to enact it. I'll give those instances. Again, in Article 367, we have, for the purpose of interpretation, the Parliament can always say who is a foreign state. Then turning over to the next page, for instance, in Article 21A, these are constitutional provisions which contemplate formation of law by Parliament, each one of them. So Article 11 talks about regulating citizenship by law, there is a law. Then Article 21A, right to education, there is a law. Then Article 22, Parliament may law prescribe circumstances so and so. Preventive detention, there are legislations on preventive detention. Then 32, so of course, the Parliament has not so far done that. It's good that they have not done that. Then 33, you can skip that. Then Article 35, notwithstanding anything in this Constitution, Parliament shall have and the legislature of a state shall not have power to make laws with respect to matters which under clause of Article 16, clause of Article 32, so and so, we provide for law made by Parliament and for prescribing punishment, declare, etc. There is no state law, of course, that's forbidden. In Article 59, conditions of President's office. So the second schedule continues to operate. Then Article 70, Parliament makes such provision as it thinks it for the discharge of the functions of the President, any contingency not provided in the chapter. There are some rules issued under Article 70, and 1969, there is a very skeletal law. Then in respect of these 71, Article 71, election of Vice President, there are legislations. 75, regarding ministers, the legislations and composition of council, all these where legislations have occurred. Again, for that matter, kindly turn to Article 102. It talks about disqualifications for membership. So we have provisions under the Representation of People Act providing for disqualification. There is a disqualification legislation 1959 that after a lot of amendments. And therefore, law has intervened, Parliament has intervened because they're very important, the life of democracy. You don't provide disqualification, criminalization of politics, all that. We have the intervention by this court in Association of Democratic Reforms, the right to know, being read into Article 19(1)(a). So Parliament has come. Then Article 105. In other respects, the powers and privileges and immunities of each house, Article 105, Clause 3. Of each house of Parliament and the members and committees of each house shall be such as in time be defined by Parliament by law, and so defined shall be those that are the House and members and committee immediately before the coming into force of Section 15 of the Constitution Zones Act 1978. Your Lordships know that so far there is no law relating to immunities and privileges. We have debated it from 1965 onwards, the Keshav Singh. So there's no law. Very important that freedom of speech within the Parliament, outside, whether there is a complete immunity, so on and so forth, a matter of great importance. Then Article 119, regulation by law of procedure in Parliament in relation to financial business. Article 120, language abuse in Parliament. Why I may skip some of this provision. And you come to a provision like Article 239 AA. So this is a field which is now occupied by law. And so the reason is that territorial distinctions, state reorganizations, etc., are again matters of great importance for the federal structure of the country. And Article 267 relating to contingency fund, or just ahead of it, Article 262, interstate rivers or river valleys. We have a law relating to that, 1967. So it's an important, again, a federal issue and sharing of waters. And despite the Interstate River Water Disputes Act, we still have interstate river issues and commissions after commissions. And so these are examples where, having regard to a wide range of constitutional considerations and importance, Parliament has enacted and intervened. And some of those provisions may have some bearing on giving effect to the directive principles of state policy and so on and so forth. Let me take your Lordship through my part 2 of the note and then try to find out which is the best way of possible way of understanding the very important issues. And may I read it?
Yeah.
When an instrument of law is unable to serve its intended purpose, either on account of defects in its operation, enforcement, or implementation, or due to its purpose not being realized, it may be said that there is a vacuum in the law. In the event that such a vacuum exists, and this Honorable Court, when engaged in dealing with specific instances of this issue, also finds that the intended purpose of the law is not being realized, it may, in furtherance, or the principle of enabling the realization of such purpose, embark upon the exercise of engrafting principles which may advance the same. This is different from the instances where no operational or functional deficiencies are demonstrated, but aspirational statements or an idealized situation which will meet that aspiration is set forth before this Honorable Court. The later categories of instances are ones that will preeminently call for political and parliamentary debate, whose outcome will be the creation of substantive legal norms or changes in the existing legal norms. This second category will not be a case of a vacuum to be filled. Interpretation of constitutional provisions towards effectuating enjoyment of fundamental rights is different from changing the text of the constitutional provision itself. In other words, such interpretative exercise will not and cannot enter into the domain of making substantive normative provisions in the Constitution. In this way, it ought to be noted that the directives issued in Vineet Narayan were nothing beyond judicial approval of the recommendation made by the Independent Review Committee. These recommendations came to be approved of the Honorable Court as worthy of acceptance towards effective functioning of the concerned investigation agencies. The use of the word vacuum in paragraph number 14 of the judgment must be therefore seen with reference to proposition number 1 above. Similarly, Vishaka was an instance of a complete absence of a relevant legal protective framework towards safeguarding the concerns of women at workplaces. The issues relating to protection of women at workplaces, having been addressed in international legal instruments, this Honorable Court has persuaded to treat such legal instrument as a guiding and relevant factor for enacting domestic legal framework. The question in that case did not involve altering any existing constitutional or legal principles occupying the field. A comparison with Article 105 relating to the powers, privileges, and immunities of each of the Parliament may also be illustrative in this regard. Questions relating to the scope of powers, privileges, and immunities have arisen a number of times and have also been considered by the Supreme Court in the following cases. Now, under Clause 3 of Article 105, Parliament has been conferred with authority to define powers, privileges, and immunities of each House of Parliament. However, Parliament has chosen not to make any enactment in this regard thus far. In considering the issue, namely in the context of an argument regarding the power having been conferred on the Parliament and not having been exercised so far, this Honorable Court in Rajaram Pal so and so observed as under. Similarly, if Article 1053 provides for the power for expulsion, though not so expressly mentioned, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make a law on the subject, is no reason to say that a law has to be mandatorily passed, and the Constitution itself provides that all the power to the House of Commons until such law is made. Thus, it is seen that even in the matter of such importance and relevance to both freedom of speech and also the powers, privileges, and immunities, this Honorable Court has not considered a non-enactment of a law by Parliament as a vacuum or a gap to be remedied by a writ of mandamus. Similarly, in several other provisions of the Constitution, the Parliament has been conferred the power to make laws.
This is very important what you have.
Yes.
This is the thing which is very important. You read on, yes.
Yes. However, the context, relevance, and the demand, etc., under those provisions vary greatly, and there can be no general proposition that in all such circumstances, the lack of an enactment by Parliament will be understood as a vacuum or a gap. That's a very important submission. I thought your Lordship will consider.
Very fair on your part.
What is being canvassed is, we say because there is an aspirational provision or an ideal situation to be attained, may be good enough. Therefore, imagine there is a vacuum because this is not there in position. Imagine a vacuum and then try to fill that vacuum. So that's why I thought it's important to look at the other scheme of the Constitution where you can't say simply there is a lack or a vacuum or a gap merely because Parliament has not enacted. So the wide range of considerations, policy, etc., will enter into the domain of decision-making process. While I say that great amount of responsibility, I don't want to be taken to mean that merely because it is so in other parts of the Constitution, certain very important schema of the Constitution will require special attention. And I say, no, you must close your eyes to that. But the reason is that we'll probably be very slow and find out whether, how do we really enter into the debate is the first question to be seen. So after the court enters into a debate and finds there's a room for a debate, then what the court will do, can do, or may do will be a second part of it. But the two are integrally connected. The petitioners herein have placed reliance on the 255th Law Commission report, dated 12/3/2015, the Dinesh Goswami report 1990, the report of the National Commission to Review the Working of the Constitution, and the report of the Administrative Reforms Commission, January 2007. These reports are essentially based on comparison with schemes relating to election bodies in different countries. The recommendations contained in the reports are not premised on any concrete set of facts, throwing doubt or concern as regards the working of Article 324(2). At best, these reports can be said to be aspirational and not critical of the current system obtaining under Article 324(2). Respectfully submitted, there are important conceptual differences between functional or operational vacuums in a statute, which may require remedial measures and intervention, and an aspirational ideal situation. Even in the case of functional or operational vacuum, well, the court will not always proceed to issue binding directions for enactment of a law or a rule or a scheme. It will be all the more so in the case of mere aspirational provisions. Article 324(2) does not contemplate that a law will have to be necessarily made to replace the system of appointment prevailing thereunder. The addition or insertion of a collegium structure in Article 324(2) will be a constitutional amendment. It will have to be in substitution of Article 74 of the Constitution, which provide that the President shall act under the aid and advice of the Council of Ministers. Such constitutional amendments, which are to be deliberated through parliamentary debate and intervention, cannot be subject for issuance of a writ of mandamus. The range of instances in respect to the Honorable Court has exercised the enforcement authority for fundamental rights under Article 32 are clearly distinguishable. Besides the fact that those cases are matters involving direct infringement of fundamental rights by reason of functional or operational deficiencies or gaps in the relevant law, or being cases wherein the enjoyment of fundamental right is not facilitated or enabled due to lack of a requisite legal instrument. In all other circumstances, this Honorable Court has declined to invoke the power of authority of mandamus. The Honorable Court has also declined either to issue a writ of mandamus or to command the enactment of a law where the statutory or constitutional provision in questions are of an enabling character. The University of Kerala, so and so, a division in the Honorable Court framed the following questions for being referred to a larger bench. Whether the court by an interim order dated so and so can validly direct implementation of the Lingdo Committee report. Whether the order dated so and so really amounts to judicial legislation. Whether in our constitution the judiciary can legislate, and if so, what is the permissible limits of judicial legislation? Will judicial legislation not violate the principle of separation of powers broadly enshrined by the constitution? Judiciary can legislate in the opinion there is a pressing social problem of public interest, or it can only make a recommendation to the legislature or authority concerned with connection. The Article 19 once here, fundamental rights are being violated when restrictions are being placed on the implementation of the Lingdo Committee report with an authority of law. And what is the scope of Articles 141 and 142 of the Constitution? Do they permit the judiciary to legislate and perform the functions of the executive wing of the state? On a reference of being, such a reference being made, a bench of 3 honorable judges, while not entering into the question frame, observed as under. Submitted behalf of the party that acting on the recommendation so and so. Elections of the students in are being held in their act in accordance therewith. When the instant matter is called for hearing today, it was submitted behalf of the parties. Elections are presently being held in terms of so and so, etc. No issues, live issues survives the scrutiny of the court. In the view of the matter, we feel expedient to leave the issue at that for the present to be examined in future in an appropriate case with the occasion so arises. I just want to flag it so that that's right. In the instances that the Constitution prescribes the Parliament has the power to make a law, it can be for a variety of needs and circumstances. Therefore, merely because the parliamentary intervention is suggested in a provision, does not mean that the court will interpret silence thereunder to mean that an explanation is owed to the court as to why a law has not been enacted. For the aforesaid reason, and keeping in mind the separation of powers principle, the Honorable Court will please decline to interfere in the above petition. Please come back to paragraph 10, again on the 4 reports. Yeah. At least I was part of these two reports, one the 256th Law Commission report and the report the National Commission to Working with the Constitution. I was involved in it, and therefore I speak with some personal knowledge. What were the perseverance which went into the making of the report? And certainly the reports were made with high purpose of ensuring that the values of the Constitution shall be advanced. But I have one problem. Because today, unlike UK, the Law Commission's reports, I have a small survey of how many reports have become, translated into law. Roughly 50% of the reports have become translated into law. So 255, 100 reports, the rest 124, 25 have become law. The percentage of acceptance of reports in various Commonwealth countries ranges somewhere between 40 to 50%. So it seems to the position almost in all the Commonwealth countries. In Australia, again, the problem was different because issues like abortion, pregnancy, and certain other racial issues, that native tribes issues. So again, there has been a heated debate as to how do you accept certain reports, except through a parliamentary debate. So there is a convention now in UK. There's a protocol. Under this protocol, a Law Commission report of the United Kingdom is placed before the Parliament, and the Parliament then looks into it, and an action taken report is called for on the basis of that, then the government tries to proceed thereafter. We don't have that kind of a mechanism. Therefore, in the absence of a connect between the Parliament and the Law Commission reports, so if the court were to say, we find wisdom in the Law Commission reports, and therefore they should be considered for acceptance, that may invite a certain constraint on the government, then which law commission report should I accept for consideration? Therefore, there can be a possibility. The court says in this, yes, consider that. So that can again become a matter for repeated judicial intervention, that every law commission report will have to become a part of the law. Therefore, that important area where social, political, and other considerations which may enter into executive decision making, parliamentary intervention, parliamentary application, all that perhaps should be left as flexible as possible.
Attorney
Your
General,
Lordship.
if I may just,
And
you referred to various provisions of the Constitution.
Your Lordship.
Where, as enacted by the Parliament,
Your Lordship.
that expression finds space. And you have also brought in the context of what you are now submitting about the Law Commission reports and the Goswami Commission reports, that functional and operational vacuum, these are the words that you have used.
Your Lordship.
Now, if you revert back to Article 324,
And then
324.
324.
Now, here, what is the Election Commission expected to do? Superintendence, direction, control, preparation of electoral rolls, conduct of all elections, parliament, legislature, everything. So these are the various functions which are noted in sub-article 1. Now, Election Commission shall consist of these people. That is the other thing. Now, if that would have been the intention, was there any need subject to the provisions of any law made on that behalf by the Parliament? If that was not there, you would know that these are the functions to be done by the Election Commission. So somebody may be an outstanding cricketer. Your AG has been a cricketer of some repute. Somebody may be a great artist or a theatre person, but he may not be suitable for becoming an Election Commission member.
Right.
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 So therefore, perhaps the constitution makers intended that we need to have a legislation in place which will give an indication. And if you look at the election commissioners that you have appointed, they're all former bureaucrats. Obviously, they have a great deal of experience of how elections are conducted. Perhaps all of them have been at some point of time election officers as a district magistrate.
Possibly.
Correct.
I
So
can.
therefore, you will not have a particular category of people coming into the domain of election commission. So therefore, giving analogy of other articles of the Constitution where they say as law made by the Parliament may not have much bearing on particularly the functional and operational vacuum aspect that you are trying to draw attention of the court to.
Yes.
So we'd just like you to keep that in mind,
Okay.
because a lot of your submissions so far is with reference to provisions where we are having a situation that there may not be. I mean, the Article 142, I mean, the courts, they do their business as maybe, what is the expression, Article 142, it is there.
For doing complete justice in a cause or a matter.
That's right. So therefore, and who are these supposed to be doing? The judges are supposed to be doing. And they're expected to know, right? So even if there is no, I mean, at least presume to know. Let us take it that way. Give us the benefit of that doubt. So therefore, the analogy that you are trying to draw before us,
I try to explain.
you just keep that in
I
mind.
keep it in
That's
mind
all.
and try to explain. Because first I thought it's important for us to know an overview.
No, overview.
An overview is important because we look at it in isolation. Perhaps we don't get the total picture. So we must have a total picture. So while getting a total picture, my idea was not to say that there is a mechanical mirror, view between these provisions and 324. I'm not saying that. Having regard to a wider range of functions and needs and demands under the scheme of the Constitution, the Constitution makers thought Parliament will always at some point of time intervene and make a law in order that the subject is governed by a positive law. So a positive law will be made by Parliament, and thereafter the Parliament's application of mind and the desirability of making a law, the contours of a law, the principles of the law, all that will be a matter of parliamentary debate. Therefore, different needs, different compulsions, different circumstances. So when it comes to article, therefore when you apply a same yardstick, can you apply a same yardstick? Wherever Parliament has called upon to make a law, you will say there is a compulsive need which can be commanded by a judicial intervention saying, I ask you to command, I obey this. So that
We are not
kind of
asking
inflexible.
a judicial, you said that we should do it slowly. And we know you have a flair for literature. They say that make haste slowly, but 72 years,
Exactly. I see that. The 72 years is something
so
which is,
slowly, yes, but
which has
make
to be-
haste slowly.
I understand. I wouldn't say no to that. A 75 years, 72 years is just again another very important, let's say, a milestone. We look at it. Even in political rhetoric or political debates, you look at a 75-year-old republic compared to a 300-year-old republic of the US. So you have 300 years of learning lessons under the Constitution. We are a young republic, but still we have learned a lot of lessons. Good enough for the short
Our
period.
democracy is much stronger.
That's right.
The black people in America, they got the right to vote only, how many
Absolutely.
years? 50s.
Absolutely. For instance, it took, even after Brown versus Board of Education,
That's right.
1954, it took more than 30 years before that law can be really implemented. And on the lighter side, while traveling to New York and going to the airport, the cab driver engaged me in a conversation, asked me who you are, and said, I'm so-and-so practicing so-and-so. He said, our Supreme Court in Brown versus Board of Education. And I was really, impressed by a cab driver talking to me in constitutional
Could
language.
be an Indian.
That is the
Could be an Indian cab driver.
So why I wanted to see this, the total picture must be before the court. And how do you draw lessons from this total picture and then the context in which the court may enter into a debate, I thought it was important for the court. That's the only reason I keep copies. Yes, I complete. So I was at paragraph 10 about those law commission reports and the commission reports. So again, we need a framework of thought or an idea or proposition in the context of which the court may say, I choose this report because of its weighty persuasions. And this report therefore deserves acceptance, and I therefore commend to you to accept this report. I have one question, whether the court would then enter into the question of the persuasions in a commission's report and say, yes, they're worthy of acceptance, and then say, yes, they're not only worthy of acceptance, but they also, I ask of you to translate it into a legal framework. Where will that kind of a constitutional survey disposition will enter? Because that's why I said there are a number of circumstances when legal reforms will require deep engagement of both at the societal level, at the democratic level, and the parliamentary level. I'm not saying this is an issue which I'm not saying that, but don't look into it. But I'm only trying to flag that so that
To be done carefully.
That's right. That's all.
Whatever we do, to tread carefully.
Don't do it.
Come before for debate before the court
No, it is.
on personal laws and
The point is,
I'm sorry.
ultimately, the core issue
Your
that's
Lordship.
going to emerge, as we perhaps think, is that what is the value that we attach to many of the core issues, core fundamental principles which are
Yes,
with
yes.
our body politics. The first is that we are a democracy. At the core of democracy is the holding of periodical elections. Now, Article 19(1)(a) gives a fundamental right to citizens to express their views by choosing candidates of their choice. The purity and transparency of the elections are intricately intertwined with
Absolutely.
democracy.
Absolutely.
Now, democracy has been held in Indira Nehru Gandhi to be a part of the basic feature. So these are all not matters which, as you very correctly say, admit of simplistic solutions. But that should not prevent the court from wading through fairly convoluted set of web of issues and finally find light, if there is light,
You're like, absolutely, you're right.
and find out if there is a way to deal with which is the next important thing. Because you took us through a number of constitutional provisions. The importance, as you very correctly pointed out in one of the paragraphs, will depend on the context. Now, here we are dealing with the context. You must recall that in the Constituent Assembly debates, Dr. Ambedkar, with the usual prescience that he had, he said this is going to be the biggest headache for the future generations, this article. So he foresaw that this is going to happen, and it's happening in our court today, unfortunately or fortunately,
Yes.
whatever way it is.
Yes, yes, yes.
So, which is that you have to deal with this issue. So, after 70 years, working of our constitution, we have given you the realities on the ground, which is the way in which, consecutive governments have appointed chief election commissioners, knowing fully well. See, the whole point is finally what? So finally, each party which comes to power would like to be in power, perpetuate themselves in power. So that is the whole thing. On the one hand, a party which has come to power would like to remain in power. Now the question is how that has got anything to do with the individual fundamental right. That's the issue that you're raising.
You're
Correct. Now what it has got to do with is the choice. Ultimately, the fundamental right consists of the real choice of the voter translating into the transformation taking place at the helm of affairs of power.
The little man with the little pencil.
Little man with a little piece of
paper. Churchill's famous.
The difference.
Yes, yes, yes.
So we can't be, looking at it very simplistically as, it's a very complex web of relationships.
Yes.
But the value is at the very, very core value. It's at the very root of our constitution, which is having a democratic form of government. Whether we should retain that, enhance it, or whether we should slip into, some other form, finally over a period of time. The example which we gave you was very, very disturbing because we saw from 2015 over a period of 8 years. You have how many chief election commissioners? So this is kind of, pick up somebody, give him a highly truncated office. So you are keeping him under your feet. He is doing your bidding. At least it could be said so. We are not saying that it is.
Right.
But at least it looks so. The same was the position when the UPA was in power. Each government, irrespective of the political color, wants to perpetuate itself. There's nothing wrong.
Right.
That's a right. I want to be in power. But equally, the people of India have a right to say, okay, you may have a right to be in power, but do it by maintaining the purity of the election, fairness of the election. This is, it percolates down to the exercise of the right of the individual, the citizens.
I'm only trying to
That is
find
where
that
we
connection.
are trying to
If that is live connection, that the independence of an electoral body, spreads out like the spring wheel in all directions, and each one of the wheel, spikes of the wheel makes sense for the total wheel itself. I understand that. But whether it has really happened, like for instance, we no longer have the days of booth capturing.
Pardon?
Booth capturing. We no longer have those days. So the days when the election commission itself, whether the state level or otherwise, was seen to be a compromise in certain election situations. Therefore, in Mohinder Singh's case, this court went into the question of the scope and amplitude of 324. And the rules or instructions the election commission can, within that 324, what it can do. Therefore, it has done several things. Parliament has enacted laws relating to voting rights and then conduct of election, registration of political parties. So many aspects of it have been occupied by rules and legislation. So the election commission has set up guidelines and instructions emanating from Article 324. And they virtually in the nature of a positive law, which every electoral officer will have to obey. When where there is a disobedience, of course, there is an election petition or even sometimes writ court interferes and says that that's why even in Mohinder Singh says if it advances the process of election, a writ court may intervene. If there is any part of the process of election. So recently, a lot have said in a case from Goa, the same proposition. Therefore, but ultimately the connection between an individual participating freely and fairly in electoral process, if there is going to be some impediment on that by reason of this president having the power of appointment, then one can look into it. If that connection seems to be little tenuous, or it is not demonstrated to be so clear, then certainly the court may sit back and say, is there a need? 25 years or 50 years could be a different question. But even at a 10 years point of time, the need is there, and Parliament should have intervened. Therefore, that's why the connection between an individual participating in a free and fair election and the electoral body, for all practical purposes, functions as immune from any political interference. If that is guaranteed, then of course there is court intervention may not be called for. For the importance here.
The problem the problem is, it is one thing to say that the Chief Election Commissioner, once he is appointed, he enjoys a tenure of 6 years unless he attains the age of 65 in the midst of that term. Or that his terms of, his condition of service cannot be varied to its disadvantage after he is appointed. The first proviso to 324(5). That is all very good. But there are two limitations on that. The first is the man himself. Who is the man? How do you determine? Because it's a $1 billion question, or perhaps even $1 trillion question.
Yes.
How do you search out and find out the ideal man, the best man? We are not here talking about, like you pointed out, the staff of the Parliament. Here we are talking about somebody who is even a status something close to the Supreme Court judge.
Yes.
So the Supreme Court judge makes it to this post through a very fairly elaborate process we have. Now, all of that is short-circuited by what you have under Article 324, which is the Council of Ministers. Now, if a law were to be provided, we can look at it slightly differently. Supposing the founding fathers did contemplate that a law, because you will see from the debate that when the last speaker was Dr. Ambedkar, he said, there's a lack of time.
Yes.
And we have to rush through. And then the amendments of Saxena, Professor Saxena was rejected. And Dr. Pandit, he also had various concerns. Both of them he did address, but then finally it is Dr. Ambedkar's amendment, what we have today, that was carried the day. So the concern which they had, they could not have possibly, seen what is happening today on the ground. Yet they were tall men. Let us admit that. And they were imbued with the values which perhaps do not pervade society today. So many things have changed on the ground. It's a fluid situation, it's an evolving situation.
Absolutely.
Now, if you say that generations of judges, after several years after the Constitution is framed, will be held in bondage, to what transpired at a particular point of time, and that we are prisoners and we are completely sort of helpless. It's a way of looking at it. We can only say that.
I don't think we need to visualize that.
One more thing. CSE records before us, that is the common compilation filed by them. There, the introductory part, at page 428 onwards.
Compilation.
That is compilation 1, volume 1, common compilation 1.
Yes.
There it would reveal that.
Page number what?
No, 432. 432.
432.
It would indicate that as early as on 9/1/90, the then Prime Minister Sri Vishwanath Pratap Singh thought that the outlined electoral reforms have to be made. And that is at page 432.
Yes.
And one of the most important reforms which he indicated, which are to be made, it is second one. Strengthening of the Election Commission and securing its independence. So as early as in 1990, he thought that these aspects, it requires reforms. That was in 1990. And despite the passage of about still where were we?
No,
See what is written here at
Yes.
432 on the margin side. Outlines of areas of electoral reforms indicated by Prime Minister. Then second one on the right hand side. Strengthening of the Election Commission and securing its independence. So such a reform is utmost importance. It is to be made. That was the suggestion made by the then Prime Minister. So that you realize, that is why at the outset also said, you realize that an obligation is there and you will have to take some steps. This was felt long ago, decades ago. Still, the notes and the last part of the note of part 2, there for that, the reasons given there and the last parting part of that note, it says, for the aforesaid reasons and keeping in mind the separation of powers principle, this court will be pleased to decline to interfere in the above petitions. So when you yourself thought that it is required and not having taken anything, whether still the court should remain as a mute spectator.
Yes, I'll try to respond. In the life of a nation, on very important and vital matters, either the parliament or the executive does not act uninformed. It must inform itself. And there are a variety of ways it may inform itself, like a planning process of drawing up for urban planning. It must inform itself. For the purpose of informing itself and understanding the aspects where there is a need for executive action or a parliamentary intervention, how does it inform itself? So there are different distinct modes, and the commission of inquiry is appointed. So these are methods and means by which the information and the assessment of a situation is gathered by the executive, and then if the executive thinks, yes, this must now go to parliament, it goes to the parliament. There can be situations when the executive assesses, receives information, and still either implicitly or otherwise does not either accept, or they don't accept, or they don't. In very often, it's a common practice not only in India. I find across the globe, when this kind of information process reaches the executive, how do they respond to it? There is no one set pattern by which the executive responds to an information process. It is conditioned by a wide range of political, social, and other factors. So therefore, the mere fact that information has reached in the domain of the government, probably it's easier to say, yes, what are you doing with it? It says there's an urgency in it. There's an importance involved in what are you doing with it? That question will again become a social and a political and a parliamentary debate. My only concern is that whenever there is an information on any aspect, by way of a report before the executive, will the court say, now, what are you doing with this? The problems involved in this. I'm not saying that the court will
This
not
is not
order
an information
I'll answer.
received.
I know.
This is one of the reasons which ultimately led to the constitution of the committee.
Yeah, I only.
Going by the what is revealed from page 4.
I'm not trying to resist any response. I'm only trying to say, how do we really look at it? Because after all, it's a dialogue between the court and the officer of the court. So I am not even trying to say what I close my mind because I already some preconceived ideas. Let me only go on those lines. I'm not doing that. I'm only trying to say that I'm asking questions because of the way I think we get illicit answers, answers which will be in the best interest of administration of justice and progress of law and rule of law, etc. That's how so I'm correct on that. Therefore, I ask myself a question: if there is an information, a survey, and a report, so at what point of time, under what circumstances will the court, if it is all his attention drawn to it, and in what framework of a proposition, the court will say that now I think, in my understanding, in our understanding, this ought to be done. That question is a very important question. So there, considerations such as any number of reports, or I find these reports are by and large swap the same language. They are a very general character, strengthening the electoral body. I can understand if there is a specific recommendation made, saying, look here, we have analyzed, for instance, if the government had to look into all these appointments, 8 years to 3 years, 150 days, something which is very wrong with the system, we must look into it. If the commission has gone into it and said it has analyzed it, and said, yes, it doesn't inspire confidence in us that the system is working well, perhaps the president in an appointment process is not effectively advised by the Council of Ministers. Then what will the court or what other process of social debate will be initiated is the question. Therefore, I am only saying that this generality of recommendations and reports need not be necessarily a trigger point. If there is a concrete report, for instance, law commission reports are very often concrete in certain situations. Sometimes they are also very general. I've seen that. So if there is a concrete report and there is a reason made out, a good reason made out, the report, somebody will not be able to sit back and say, I don't accept it, except for political other consideration, which can be tested in a court or otherwise. Therefore, a very generality of a report, without probably not premise on certain concretization and other aspects, may or may not be a matter calling for the court's intervention, is what I was trying to say in my last paragraph. I am not saying these reports ought to be belittled. That's not what I'm putting it. The reports will have their weighty importance, certainly.
These are only for consumption.
Yeah.
They are apprising them, being the health affairs, what they thought. Make it available to us.
Yes.
Make it available for the public.
Yes.
Make it available for the parliament.
Your Lordship, please.
Look into.
Yes.
And whatever is best possible in making a transparent system.
Your Lordship, please.
In evaluating, in assessment,
yes,
in selection, lay down under the framework of rules which you have the parliament to implement. We are not, don't mistake that we want these reports to be implemented. No, these reports are available to examine as to what should be the best modality which can be adopted in a fair mechanism, acceptable mechanism, and in upholding the this election process. And being a democratic country, we must have, I think there is no.
I quite see that.
So that is only for this purpose.
Absolutely. I mean, when
we may examine all the reports, but may not agree looking to the submissions being made, and we find some different mechanism in place.
That's right.
For the purpose of proper implementation and the fairness in the process. So we are at the root cause first.
I quite see that. What Lord
we are at the root cause first as to whether any mechanism in place is required in making a selection on the post in question, or we leave it to this your Council of Ministers and later on the Prime Minister and the final order by the President. You see all your act and rules. First is rule of business. Rule of business only describes which matter goes to which place.
That's right.
Nothing more, nothing less.
That's only deal the process.
Second is only laying down their service conditions.
Correct.
So the person, we are not on those. We are the stage how the mechanism in place for the purpose of appointment. After he is appointed, he will be governed by the Act of 91 laying down the service conditions. So we are not at that stage. Conditions are there. Now, see the data made available. Not one person after session has been permitted to have a 6 years of term. And if you're appointing these civil service officers, they retire at the age of 60. And by the time you consider them, to follow them, 2 years have passed.
Right.
So hardly get the time for one to put its vision and to make the system more better and acceptable. So something has to be drawn line somewhere.
I just as an attorney addressing the court, I'm sure I'm not a mere mouthpiece of the government. But at the same time, I must share to the extent the concerns have been raised. I may share them, and as an officer of the court at the highest level, I'm only trying to share them. And I quite see what you're also putting to me that regardless of any other consideration, if several voices are spoken on this issue in different reports, there is something about, say, yes, why don't you look into this matter? But certainly it's important for the state to listen to it and see if something can be done. But why I am trying to go on this very lengthy exposition is that the For instance, Vineet Narayan is repeatedly suggested, or Vishaka is repeatedly, invoked. In circumstances where they ought to be invoked, there can be no debate at all. And it must be done so. And that's the best way of expounding the fundamental rights and freedoms in the Constitution. But when they are invoked in certain extended circumstances, and then sought as a precedent, said use this, and therefore I thought for the purpose of your lordships trying to look at it, it is very important to draw your attention to all that. I also looked at, for instance, the TN Session judgment.
That is Chief Information Commissioner also we have intervened. For appointment of a Chief Information Commissioner, this court has intervened in making.
That is in the context of.
In making a
No, I'll
committee for the purpose of.
No.
What judgment is there?
The secret judgment.
Chief Information Commissioner.
Yes,
Anjali Bharadwaj.
Yes. Anjali
I'll
Bharadwaj,
just come to that.
I had mentioned
That is
judgment.
that is in the context of an actual appointment debate. Actual appointment debate. So therefore, concrete situations when the court may intervene, whether you have picked up a wrong person or a right person, have you acted for wrong consideration, that will be entirely different. We are on a doctrinal situation. Therefore, to invoke those instances in a doctrinal situation when, for instance, we have in administrative law, we have several doctrines with like a common law growth. Right? It has happened. Legitimate expectation, proportionality principle. They are doctrines which the court has evolved, and then they are well evolved and working well to ensure that the constitutional system functions on a fair basis. But therefore, these kind of instances where concrete situation, court will always interfere and say, I strike it down, I don't allow it. Now, if I was trying to look at the TN Session judgment, I'll currently come to that. Let's say if TN Session marks a little watershed in the whole electoral debates, both the person and the scheme. So, I think important things have happened thereafter. Sometimes individuals make a difference in the scheme of things. Your lordship knows better. So, I was looking at one of the arguments advanced is look at the other election commissioners, tenure and removal. They must be placed at the same position as the chief election commissioner. TN Session has looked at it. 5 judges bench has looked at it. I just get me TN Session.
Okay. Prior to
Sorry.
session, nobody knew that there is some post like Chief Election Commissioner. He was the only person who made known to the people at large, this country, that there is some post like Chief Election Commissioner who has some power to see that the purity in election process must be upheld, which is the primary consideration to uphold the democracy.
We had other problems, but yet do not assert it is.
Everyone has something, but let us see the positive side of the coin, the way the man has proceeded.
Well, the NOAA also throws some light on that, where it started with the notification, though notification was taken back, and the allegation against the Chief Election Commissioner by these two appointees that the post is deleted. So that's a question that's where it started with that. Then later on, when it came to MS Gill, and Justice Venkatachalaya in 2 paragraphs very clearly said that, and interestingly, when it was MS Gill, in my share of submissions, I make that. There also, a request was made considering that the election in Punjab was whether that was a opportunity of hearing to be given a debarred candidate or not. That was the question. And the larger issue was made and said that you should lay guidelines in that case, that there should be a natural justice in that. After considering entire scheme in 324(2) also, in the last paragraph, court says that it is good to, we don't want to embarrass the institution. It has gone down to that extent, say that we will not make guidelines on that part. So that is an examination and test given therein. But I'll make my submission, only one part. The statistics which my lords have given today to say that in last 7 years. So if we see that the trend in last 8 or 9 or 10 years, at the same time, 2 elections have taken place, and I have a stats of 2021 election. 912 million people were eligible to vote. 67% voted. and there is not even a single allegation barring some small incidents that the election is not fair and pure. There is a functioning of an institution which has functioned over a period of time. Well, a democracy is like a leaking pipe. You try to plug one hole, you need to see that it's going to be leaked somewhere else. So if we see, and this is there is a context in which I'm referring to in a multiple jurisdiction, this test is there. And there is enough reason why, if we look at the constitutional debate also on this, 3 options were given at the initial stage. One, to put it in the fundamental rights chapter, taken out. First suggestion came in the original shape minus the subject to law provision which was there. At that time, the suggestion was made by Professor Saxena that so far as the appointment is concerned, let us leave it to a 2/3 majority of both the houses, not agreed to. Second suggestion was that we come out with the instrument of instructions, like in US, that because US seems to be very onerous in terms of a time it's going to take, and sometimes we need these election commissioners to conduct election in a shorter period of time, and the parliament may not be in position to appoint and all that. So cut short formula was given that we come up with the instrument of instructions. What those instructions can be, when the parliament said that no, we don't want to come up with that instruction, or rather the framers said we don't want to come up, we are happy with this clause with being added subject to law. What it means, today those instructions can step in some other form by some other institution. That also is a question which requires consideration. I'll make my submission at that time.
Yes, it's here in this compilation. The same compilation. Volume 3. Okay.
Volume C. Volume C. Volume 3.
Escape. Before I read TN session, in the compilation volume 3, we have
Volume 3,
Indira
1509.
Nehru Gandhi volume 3.
It is in 1509 volume.
Couple of paragraphs. Before I come to TN session, you'll also kindly turn to the Indira Nehru Gandhi judgment, which begins at page 1096.
Volume 3.
Volume 3. Just get me the 277. Page 1247. I look. The concurring judgment of Justice Matthew at page 1243, paragraph 277. I keep in mind this very important question, what you said, that connection between the participation of a voter in the most free and fair manner possible, unbridled by any impediments, which may be in the nature of an election body being, not neutral and impartial, or any other consideration. Then look at if it is the reason of something which is unconnected with the electoral body not being neutral, then different considerations will follow. But if it's something to do with the other set of factors which may inhibit a voter from exercising her franchise in a free and fair manner, then different considerations will follow. Then the court may look into whether there is a law dealing with that, whether there is a failure under the law, and then who is responsible, and whether a law provides for a remedial measures in those aspects. All those considerations will be different. But when you're talking about the electoral body, the election commission will not functioning in a neutral, impartial, or it has abdicated its functions and powers, leading to the disabilities imposed on a voter to participate in a free and fair manner, then the court will have to find out, has it really happened? And then how do we have tests to find out whether the connection between this and this is made out? There we have some very nebulous area. That's a very nebulous area. Unless concrete fact shows yes. I'll give you lordships probably later. I was looking at the position in a country like South Korea. South Korea.
Sorry?
South Korea.
South Korea.
South Korea. So we have several of the Asian countries where, like some of the European countries, post-Soviet collapse, new constitutional making, like Hungary and or Herzegovina, they're all very new constitutional frames have come in. Like the Constitution of South Africa, which had a very, the apartheid issue, and therefore you deal with it. For different constitutions have enacted certain provisions, keeping in mind the importance of moving forward. And then that's why somebody says, when you want to look at the future, don't look in the river mirror. But you must have a mirror ahead. That's right. That's what you're also putting to. For instance, in South Korea, we had the country had a problem over free and fair elections. The tussle between dominant political parties and smaller political parties, and therefore a competition in the political arena. How do you deal with that? And then questions of who should be entitled to vote. All those considerations have been considered and dealt with by the Constitutional Court of South Korea. Some they have said will intervene, some have said will not intervene. So it all depends, therefore, on a concrete situation when a law will come in and intervene and make things worse, or the law will not come in and make things equally worse. So those things are important for the court's intervention. So now let me write a few passages from Indira Gandhi, page 1243, paragraph 277. Will I have that pick? The Privy Council had occasion to consider this question in United Engineering Workers Union with Devannath. I think it's better read the earlier paragraph so that it is understood. An election dispute of the public aspect is concerned more with the right of a constituency to be represented by a particular candidate. Does not follow from the public character of the controversy there is no list between the parties to the election contest. The list can be resolved otherwise than by ascertaining the fact related to the election and applying the relevant law. A judicial inquiry investigates, declares, and enforces liabilities as they stand on the present or past facts, and a law supposed already to exist. This is its purpose and end. Legislation, on the other hand, looks at the future and changes existing conditions, making new rule to be applied thereafter to all or some part of the subject to its power. The Privy Council had occasion to consider the question united so-and-so. The judgment of the majority was delivered by Lord Dillon, Lord Gus and so-and-so dissented. The question in the case was whether the president of a Labour tribunal in Ceylon was the holder of a judicial office. If so, the man in question had not been appointed in the way the Constitution of Ceylon required for appointment of judicial officers, whether the tribunal was without jurisdiction. It's clear for the judgment that lordship of the minority judicial power is the exercise of power on the basis of pre-existing law. The lordship said, another characteristic of judicial power is concerned with existing rights, that is, those which the parties actually have at the inception of the suit, and not those which it may be thought they ought to have. It is concerned with the past and the present and not with the future. Then turn over to paragraph 350. Let's hold it up. It was a very interesting paragraph at 347 on page 1260. 345? Yes. 1259, paragraph 345. I think the inhibition to destroy or damage the basic structure by an amendment of the Constitution flows from the limitation of the power of amendment in Article 368 read into by the majority in Bharati's case, because of their assumption that there is a certain fundamental feature in the Constitution, which its makers intended to remain there in perpetuity. But I do not find any inhibition so far as the power of Parliament or state legislature to pass laws concerned. 245 and 243 gives the power, also provide the limitation upon the power of the organs to pass laws. It is only the specific provisions enacted in the Constitution which could operate as a limitation upon that power. The preamble, though a part of the Constitution, neither a source of power nor limitation upon that power. Then skipping a few sentences thereafter, the line beginning these specific provisions enacted in the Constitution alone can determine the basic structure of the Constitution is established. These specific provisions, either separately or in combination, determine the content of the great concepts that are in the preamble. Impossible to spin out any concrete concept or basic structure out of the gossamer concepts that are in the preamble. The specific provision of the Constitution is stuff from the basic structure, so and so. Then the last line, the norms of election set out by Parliament, state legislatures tested in the light of the provision of the Constitution or necessary implication, therefore constitute the law of the land. That law cannot be subject to any other test, like the test of the free and fair elections in an ideal democracy. Then at page para 346 in the next page, I do not think that an ordinary law can be declared invalid for the reason goes against the vague concepts of democracy, justice, political, economic, and social liberty of thought, belief, and expression, or equality of status and opportunity as some invisible radiation from them. That's where Professor Lawrence Tribe's invisible constitution concept somewhere may have some relevance. I'll come to it a little later. Now, in the second part of the paragraph, they say definitions are important, but they're responsible in the last analysis for our image of democracy. Question is not only what does the word democracy mean, but also what is a thing. When we try to answer this letter query, we discover the thing does not correspond to the word. Although democracy has a precise literal meaning, does not really help to understand what an actual democracy is. So then real world, so Dahl pointed out democracy is polyarchies. Now may skip all that, then come to para 347. Nor it can be tested as the touchstone of justice. The modern Pilate asks, what is justice, and stays not for an answer. That always reminds me of jesting Pilate. To Hans Kelsen, justice is an irrational ideal and regarded from the point of racial cognition. You think that only interest and hence conflict of interest, the solution according to him can be brought about by an order, satisfy one interest at the expense of the other, or seeks to achieve a compromise between opposing interests. Silence in the concept of social justice is vague and indefinite. Liberty of thought, expression, belief, faith, and worship are not absolute concepts. They are emotive words. They mean different things to different people. The equality of status and opportunity are concepts laden with emotional overtone. In their absoluteness, they are incapable of actual realization. The enacting provision in the body of the Constitution alone gives concrete shape to the ideas. In the base of those provisions, the validity of the ordinary law should be tested. Then paragraph 340. Yeah, 349 and 350. This would indicate that the Constitution enters the task of framing a law relating to election to Parliament, subject to the law to the state legislatures, an important branch of the law which stands in the area of free and fair election, namely delimitation of constituencies, allotment of seats, is put beyond the cognizance of the court. It's found the task of writing the legislation subject has been committed to Parliament and state legislatures of the Constitution. Is it competent for a court to test its validity on the basis of some vague norms of free and fair election? I think not. As I said, like other laws made by Parliament or state legislature, the laws made in the Article 327 and 328 are liable to be tested by Part 3 of the Constitution or any other provision of the Constitution. It is difficult to see how these laws could be challenged on the ground. They do not conform to some ideal notion of free and fair election to be evolved by the court from out of airy nothing. The doctrine of spirit of the Constitution is a slippery slope. The courts are not at liberty to declare an act void because their opinion is opposed to the spirit of democracy or republicanism supposed to pervade the Constitution but not expressed in words. And the fundamental law has not limited either in terms or by necessary implication the general powers conferred upon the legislature. We cannot declare a limitation under the notion of having discovered some ideal norm of a free and fair election. Cooley has observed that courts had not liberty to declare statutes void because they appear to the minds of the judges to violate fundamental principles of Republican government unless it will be found those principles are placed beyond legislative encroachment by the Constitution. Principles of democratic republicanism government are not set out as inflexible rules, and unless they are specifically incorporated in the Constitution, no law can be declared banned merely because the court thinks it is opposed to some implication drawn from the concept. This is very important. Some implication drawn from the concept is what the court will probably very astute to avoid. And which 60. 460 at page number 1297. This is Justice Bake's judgment. Then we have another judgment of Justice Bake, paragraph 460 at page 1297.
On what proposition?
No, on the proposition that whether court will take upon what electoral law should be. On that proposition, paragraph 460 at page 1297. The amendment appears to be within the unquestionable power of the Parliament to legislate either prospectively or retrospectively with regard to election matters, when able to see how it's capable of being interpreted as an attack on free and fair election, which according to the learned counsel for the election petition is part of the basic structure of the Constitution. I think it's important to bear in mind that courts cannot take upon themselves the task of laying down what electoral law should be. The lawmakers, as a Parliament, assume to know and understand their business of making laws for the welfare and well-being of the mass of people in this country for the protection of democracy and a free and fair election, in accordance with the needs of the democratic process, better than courts know and understand them. It's only where a piece of legislation clearly infringes the constitutional provision or indubitably overrides the constitutional purpose or a mandate or prohibition that courts can interfere. So and so, it will see the validity of the electoral. Paragraph 526. I certainly.
What is the kind of line that you are trying to sort of adopt? What's your line of reasoning? What are you trying to tell us, like, in short? Just like to have the drift of your argument.
Apart from requesting us not to interfere. What is-
No, what is the route you're taking? You know, we just like to know so that you're free to argue in your own way.
There are two things which came to your mind, how to assist.
That's right.
One is to flag the concerns and how to flag a certain concern,
Yeah,
and how the court may look at that.
that's right.
That's it. Unless I do that,
You're right.
I don't think whatever else I may say may not fit in a context or may not be seen as
So from
relevant.
these paragraphs which you have referred to,
Yeah.
what is it that you're trying to tell us? What this court has held, so that we understand what your line of argument is. That democracy is part of the basic structure, settled law. All right. Now, this is an area where the state is, parliament has a discretion to make the law. We can't mandamus the parliament. We can't be obviously telling parliament to make a law. No, you're right. We are not going to do that. We can't do that.
Your Lordship put it, I understand.
Yeah, the only small area where we have some free play, in the joint, where we can contemplate, we can possibly interfere is to put in place a system which has been advocated right from 1990 onwards, which all political parties, in fact, Sri L.K. Advani in an article in the Hindu in the year 2012,
Yes.
he also pointed out. So all across the board, you hear voices, but they remain voices in the wilderness. They never get to occupy the center stage. But the reason is not far to seek. The real crux of the matter is this. There is a fundamental right with the citizen. Democracy is a core value, basic structure, in fact, part of the basic structure. The situation on the ground is fairly alarming, which we pointed out to you with statistics. The most important part is this. There is going to be reluctance, obdurate, obstinacy on the part of the political party, whichever color we say, to let go of a situation or a position under which they can have a free hand, but not have a free and fair elections. So this is something which is self-serving. Basically, they will not like to get rid of the luxury in which they are ensconced. Because this is something which they can say, okay, Parliament, this is, as you are arguing now, it's only an enabling provision. The Parliament may make law. It's an enabling provision. So there is no law. We don't have to make a law. If you make a law, there is another aspect also, which is very important. If you make a law, it necessarily must be something different from the Council of Ministers telling.
That's right. That's right.
That's the point.
That's
So that is, you have to really move out of that comfort zone.
That's right.
Which suits you fine. Any political party. They would like to say, okay, let this continue, continue. After 100 years, this continue. So the point is, does the court say, sorry, hands off, we are helpless? Or do we say,
I quite see. I see. I'm not closing my mind, or but what is repeatedly coming to your mind is
how do we do
maybe it can be repetitive.
How do we do it? You are right there. You have to think carefully.
I put it very carefully. The question is, but before the court will enter that stage, should we enter the stage of how do we do it? It will be the first question. So if we enter that stage, then several other considerations and questions will open up.
That is secondary.
That's right.
First,
But that's right. Therefore, the first question is, should the court
entry
enter it?
point bar, whether that should be maintained or there can be a side gate through which.
As officers assisting the court, we only sometimes try to rephrase a proposition and come back to it again in a more imaginative way if possible. I only try to do that to the best of my ability.
Your initial argument was that normally, if there's a lacuna in law without
That's right. That's
reaching the supplying of omissions, there can be interference. But if in the original text of the constitution,
correct.
If certain things have been left to certain authorities, court should not interfere with that.
Right.
But here, what we are really examining is the manner of exercise of power by certain high organs of this state. So that manner of exercise of power under the constitution, possibly court can get into that and test, and in the event it's the manner of exercise of power is going on for a long period of time, contrary to what various expert bodies within the political system are recommending, then whether the no entry sign still operates.
Right.
And the sum and substance of the contention
Lordship,
appears to be that the Constitution thought it fit to leave it to the Parliament, and therefore court shall not. It appears to be that.
Yes, in one way, it's because it is so. Because if the Constitution, unlike a provision in a fundamental rights chapter, In a fundamental rights chapter, things are different. The court will always read meanings into a provision of a constitution because it's a living constitution. You must move ahead with the times and to ensure fundamental rights are realized. So that is an entirely different area of reading, meaning, more meaning, expansive reading, etc. But in any other part of the constitution, different considerations will arise.
That is why we said, when you yourself thought that, of course, the constitution, it makes us, the parliament, obligatory to come up with a law. And again, some movement was there, but if you are not pushing forward for decades and decades, even then, can you still stick on this contention saying that even then, the court shall not?
The question,
How long you can?
the question would there be? May not be the question of
Yeah,
what
you
long,
are trying-
long may or may not necessarily enter unless the duration, a long duration, has shown complete aberration.
Because we are now taking
And
up this
complete-
after 70
But
years.
I understand. Complete aberration of the independence of the electoral body complete. If that aberration has
My
been
lord,
shown
sir,
nearly,
we have clarified that we are not going to issue a mandamus upon the parliament to make a law. That would be beyond our
I quite
jurisdiction.
see that. I want to get that. I'm only trying to say, because whenever you read an obligation under any law, I remember
That is
Under any law and under the constitution, it is.
Go back to
Therefore-
Bishop of Oxford.
right. Like when HLA Hart says, whenever there is law, there is an obligation to obey. That's how it is put, positive law. So, but question is, would the court say, I read there is an implicit obligation or there is an express obligation? The two things are different. If there's an express obligation, the court has no difficulty in declaring an obligation which you are breaching. But then when the court says there's an implicit obligation to proceed, because now you have, forget about what happened in 1950 and 59, 8 years, etc., well drawn out instances. We were in the process of understanding and comprehending our democratic, the election process. In the first few elections, things how it worked. So one must go back in point of time, gather facts and to find out what made it necessary for some election officer to be there for 8 years or not. We don't have all those fact situations. So if those facts have been analyzed, and then you find there is now over a period of time, they've all disappeared. 8 years was then necessary, now it is not necessary. 4 years was then necessary, now it is not necessary. So therefore, it all depends on the movement of facts, the developments and so on and so forth, and an assessment be taken on them. We really do not have all those contours in this petition. We only have a reports. I can also say, for instance, the Prime Minister, you'll also refer to that report. So internally speaking, they know better what's happening, who is doing what not, etc. Therefore, one can again only do a second guess as to what persuaded any of these bodies to go and make a recommendation this should be done. That's a second guess. From the second guess, will the court say that I read there is an implicit obligation under 324(2) for you to make a law? I read an implicit obligation. I find there is some difficulty about it. That's all I'm trying to point out. If it is an express obligation, nobody can contest it. So the obligation again in respect of what is the question? If you read Article 324(2), the president is the appointing authority. Now will the court say the president will not be the appointing authority? The court will not say that. Then the president is consulted under Article 74. Now that consultation process, next question is, if there has been an aberration in the consultation process or there's an abuse in the consultation process, which is demonstrated by all these facts over a period of time, then comes the question.
That is the area possibly where we can enter as per established principles of political science.
What's called the interstitial legislation. But even there, I wanted to only add some cautions that you'll also look at it.
No, we are aware of that, and we can anticipate on the points on which you will caution us.
I cannot Your Lordship's wisdom on that. I'm trying to share this at a certain level.
We'll come back.
Very
Yes.
May take your lordships. I sometimes I remember a death penalty case where they were arguing before a bench of 3 judges before lunch. They were not convinced that I have a case for computation of death penalty, but after lunch, the bench asked me, we would make it a life imprisonment. What have you got to say? Would you still like to argue the matter? I said, certainly not. And that's how the matter ended. So I was trying to find out if I can respond to some of the questions during lunch and you where it leads. But what is constantly coming to one's mind and not underscoring the importance of this matter, not at all. Certainly not. And I don't think I can do that. What is repeatedly coming to your mind is this: look at the contents of the reports which are placed before the court. Are these reports based on their focus, consideration of certain factors which arouse the anxiety and the concern of the government on the immediate and an urgent need for stepping in and changing the current contours to move towards a higher level of confidence for democracy and rule of law? I'm not able to find from the contents of the report that such a consideration has really taken place. I want to show, for instance, the Goswami Committee report the Lordships drew my attention to. A couple of paragraphs in the report, and thereafter to show that the Goswami Committee report has been looked into by the Law Commission and thereafter by the Electoral Reforms Commission. The Goswami Committee recommendation seems to be some kind of a genesis for later day commissions to look into them and either adopt them as it is, and it looks like that. Therefore, that raises one important question: what the court can do. I said, if the reports have certain content, context specific, and it has an evaluative element in them, and the evaluative element, on the basis of that, there is a direction to be taken, then the court may probably pick up those evaluative elements and say, how do we ask you to have a relook at those evaluative elements? But if there's no evaluative elements in those reports, they're simply based on a certain policy consideration of borrowing from some other jurisdiction and things like that, then perhaps the court's journey into that area of asking the executive or the parliament to deal with them, it becomes a little nebulous area. That's where I am repeatedly coming back to it. So let me take your lordship's attention to page 4 to 8, where the Goswami Committee report begins. Para 1.3. 1.2 and 1.3. The massive operation of a countrywide election naturally inspires global awe and respect. Holding of elections in sky-high and snow-clad mountains in north, scattered tiny islands north, thick forests and seas in vast tracts of marshy so-and-so. At the present reckoning, the electoral ministry has to plan and manage an election for electorate nearly 500 million, spread over 25 states, 7 union territories, big and medium so-and-so. Then kindly turn to paragraph 1.5. Leaving now our Lawrence alone becomes imperative to take stock of the present state of affairs, which causes real concern and anxiety because of the existence of the looming danger threatening to cut the very roots of free and fair elections. And what are they? The role of money and muscle powers in elections deflecting seriously the well-accepted democratic values and ethos and corrupting the process. Rapid criminalization of politics, generally encouraging evils of booth capturing, rigging, violence, etc. Misuse of official ministries, the official media and ministerial increasing menace of participation of non-serious candidates form the core of our electoral problem. Urgent corrective measures and need of the best so-and-so should collapse. Electoral reforms are correctly understood to be a continuous process, but the attempts so far made in the area did not touch even the fringe of the problem. They proved to be abortive. Some of the recent measures like reduction of voting age and anti-defection law laudable, and the basic principles underlying those measures should be appreciated. But there are other vital and important areas in election feel completely neglected and left high and dry. All these 4 decades especially shown the demand for electoral reform is mounting up. Subject of electoral reform received wide attention shown for many eminent persons at various occasions, relevant to make reference in brief to some of them. There are about large number of reports from the Prakash Narayan Committee reports onwards. Then I may skip this report sequence and page 431 para 1.10. Thus, there are existence, informative, productive, and useful voluminous materials on the subject. The general public has been getting the feeling that lack of political to undertake any useful exercise of electoral reforms. So if you give a quick glance at any one of those reports and the concern, which have again been noticed at paragraph 1.6, many of those reports touch on those subjects. And by and large, how do you ensure that a free and fair election by avoiding criminalization of politics, muzzle and money power, so on and so forth, have been the most focal point of electoral reforms. And that's how this committee came to be constituted. And what is generally outlined in page 432 is in the context of the background of this. Therefore, this general outline gives an understanding as to in what way put all of them together and how will we move forward in a direction where free and fair elections will be assured. Now, I didn't find in the rest of the report anywhere which deals exclusively with the question of item number 2 on strengthening the election commission and securing its independence, except what is stated here in para 432 and some broad statements somewhere here and there. I didn't find anything which would really.
437.
I'll come to that. What is stated in 437 again?
436.
It's a recommendations. These are recommendations. But what I am trying to point out is the basis of the recommendations must be somewhere in point of time that I have a survey. This survey tells me that these aberrations, distortions of abuse of power, etc., have entered into the composition of the election commission, which can be probably led or lead to a conclusion that if it is not neutral and independent, there is every possibility of every step in the election process. There are measures in the election process. Every step in the election process which can be subverted. So the idea is that such a body should not be a handmaid of the executive. That's the idea. So therefore, unless it is shown that it has become a handmaid of the executive, for reasons shown like this, and therefore we need to have the recommendation. I'm not again for a minute doubting the wisdom of the recommendation. I'm not on that at all. Because if you're on that, then different considerations will come. So then we need to have material. There will be exchange of views, which is good, which is fair. Why do we look at it? All those issues. We are not able to reach even that point of view. That is where my difficulty arises. We are able to reach that point of view on the wisdom of the recommendation based on a variety of considerations and factors. Then the court probably could enter into all of them. As I said, the evaluative element which is absent in the report. It is just a recommendation. But an evaluative element which must link with saying, yes, here is an evaluation, that the long history of appointment process inevitably leads us to a conclusion that there is a danger of the electoral body becoming a handmaid of the executive, and then therefore all that is need to be done by an election body will down the line can be questioned or become questionable. If that evaluative element is not there, then all that I have to come back to my original statement that yes, we still probably can look at it in a different way. These recommendations should be worthy of consideration. They stand on a different footing. So recommendations which are based on survey, evaluation, consideration, and conclusions. A reasoning and a conclusion. If these elements are absent in a report, will it be possible for the court to say I pick up a recommendation part of it, and then I say why government has not applied as leaned in favor of the recommendation would be a very difficult question. So I say so in respect of all the reports. There is a Law Commission report, which has picked up this Goswami Commission report. Law Commission report looks at the other, examples of other countries. They all picked up and said, yes, I think this is better to be done like that. So even for a lawmaking body or an executive to take a policy decision, it must have before it a concrete set of factors, facts, information, data on the basis of which somebody can apply their mind, analyze, evaluate, and which direction a policy can take. If that assistance is not available within the contents of the report, to simply ask somebody to abide by the report or to make it part of a law, I think somewhere there will be a problem.
You want to say that unless it is being projected, that a neutrality, which is a sine qua non,
Your Lordship, yes,
is being compromised,
yes,
and the instances are coming on record,
right.
then only the recommendation.
That will be the best way
Why
of doing.
why can't we put something with neutrality is not to be compromised,
Yes,
and we can initiate a process so that at no point of time the state should reach where the neutrality is compromised, and then only we think forward what to be done.
I would.
We don't have a remedial mechanism when we come across and confront with any kind of a injury caused to us.
I understand that.
If we feel that there is a possibility of an injury being caused, better to make changes in our own approach.
Yeah, I quite see that question. Let me try to, because we are now again trying to grapple with various dimensions of a point. I am not shying away from.
No.
I am trying to say which.
We just
I understand.
dialogue each other so that we may find out what is the better mechanism.
Right. And then what he's trying to say, he is not saying that, well, look here, don't do this. That's not the way what I'm trying to say.
You see,
In some circumstances.
in this context, it's 436%.
No, there is except
No,
the
the
recommendation.
recommendation made by the Law Commission, page 436, is the read over.
Page 437 is the recommendations.
Yes, correct.
Correct. I'm not talking
They
anything
propose.
about the recommendations at all. If I have something to disagree with the recommendation, that's a matter for debate.
That's correct.
I am not saying anything about the recommendations. I'm only saying if the court were to accept, or even a policy maker were to accept the recommendation, or what will be the basis for proceeding further on the basis of a recommendation. I said something very important is the content of a recommendation, the evaluative content, the inputs in the recommendation. If there is no guidance available, then of course the parliament will say, all right, I'll enact a law, but how do I do it? Why do I do it? Well, these are considerations which more the executive and the parliament will certainly, embark upon. It's not at an abstract level. If anything that we done abstract level, of course, our social order will proceed on a different footing. So therefore, the abstractness of it will certainly not be the guiding principle. So in that context, since I said 1990, the report came thereafter, is virtually a replication of these recommendations. And none of those recommendations, again, I find I'm not able to persuade myself. I was part of the Law Commission when they gave the report. So there is some part of the recommendation had large-scale consultations. For instance, on the question of criminalization of politics, disqualification of persons who can contest the election, we had large-scale consultations across the country. In fact, I authored the concept note and said we should have complete criminalization should be completely, avoided. But no political party, I must share, no political party was at item with us on that question.
It can't be.
So therefore, there is some blockade somewhere. We must overcome it. How do we overcome it? The Law Commission says, I want to give a recommendation, so the government will be able to consider that. So why I'm trying to say, fall back on this, I think in order, that's why I refer to the UK example. There, a system has been put in position. It goes through a process of consideration. Parliament looks into it. The Parliament then in an action taken report comes back to the government. We don't have that system. We don't have that machinery. Therefore, the first point of time, any report before the court can be inclined to call upon the executive to act on the report. Certain criteria must be internally available within the report and intrinsically adding well to the content of the report, which then probably can become a reason for a debate. If within the reports, these criteria are intrinsic qualities which can be persuasive enough to command the executive to move in a particular direction, if they are significantly absent, then will the court say yes, regardless of all those absence of those criteria in a report, for other consideration, namely, we have 75 years, 80 years, whatever consideration, or people at high level, like the Prime Minister has sometimes said, do this. Those considerations would be rather extraneous for the purpose of asking the executive of the parliament to enter into the debate. That's where I've looked into the reports again and again. I find there is this problem. And the question again comes back to me: what is that the court can do? So I have no. It's not a binary question. You can do this, you cannot do this. It's not a binary question. There is therefore again an area where, if the attorney were to say, well, these reports do not have those persuasive content, but it is certainly open to the court to ask the government to apply its mind and see where it can go ahead. Beyond that, because even that, I again look further beyond that. Suppose the court were to say, it's a fairly long duration of republic, and this is reports, whatever be their intrinsic content, there is some pointer, some signpost. So why don't you look at it? So then the next step is what will the executive is supposed to do? So they have to apply their mind, and yes, they may accept it, or they may say no, there are other reasons why we cannot accept it. There could be deliberation between the executive or the policy making level. Suppose if the government were to accept it and say this is worthy of acceptance, we enact a law. And then next question is what kind of a law? What procedure? What process? What criteria? What norms? So the court will certainly not enter into all those questions at this point of time. But then if the recommendations have to be really considered and translated into law, can you segregate those aspects, the secondary aspects, but only look at the primary aspects? I think there is some problem. This is one. The third issue is, if these reports have been able to point out that by reason of the lack of perceived, not merely subjective, lack of objectively perceived understanding that there is a live connection between the disability being imposed on a voter not being able to engage in a free and fair electoral process only by reason of the composition or the appointment process of the election commission, then one can understand. I don't think that will ever happen. That connection, I don't think, can ever happen. It will be too remote. It will be too remote for somebody to say the composition of an electoral body, because of the process of appointment, etc., can lead to a compromise on the electoral right to participate in a free and fair election. Our country has not gone into that stage at all. And the whole series of legislations and rules and regulations under the Representation of People Act, and courtesy Vaginder Singh 324 being occupied by guidelines and instructions issued by the Election Commission of India, that question, I think, will not arise at all. So that's why in para 1.3, they're talking about the other important, more important issues. Para 1.6 at page 429. And they have been by and large addressed in good measure or in inadequate measure. They've been addressed. Maybe we still need to go further on the criminalization of politics. And important steps have been taken place, courtesy the intervention by this court on Association of Democratic Reforms, that the right to know is part of the right to free and expression. So these are areas by which, where the actual concrete situations when a free and fair election participation by a candidate or a voter can be enhanced. So it's a question of enhancement, the quality of the process at that level, where the court will definitely come in and say something. But where that is not the real issue. So I think there is, acting on the basis of the reports will be a matter for a serious restraint on the part of the court. Now, the Law Commission report. Law Commission state. National Commission. See? Which page? One. And if you losses come to the 255th Law Commission report, which begins at page 155, if you look at the table of contents,
You're referring
from what I may consider as
Which
being
page?
part of the
which page you're referring?
it page at 157. So probably it is in terms of the importance of the issues, and there is, so it begins at regulating election expenditure, A, B, C, D, electoral expenditure, E, legal acumen and under-reporting of election spending, then state funding of elections. Then comes the third part, the regulation of political parties and inner party democracy. Then Roman number 4, from first past the post to proportional representation. I may stop here for a minute. This first past the post to proportional representation was also a matter considered by the Constitutional Review Commission earlier. Then we come to anti-defection law in para 5. And thereafter, we have this 6, strengthening of the office of the Election Commission of India. If you look at that, so page 261 para philosophy will read anything from para 6.1 to 6.8. It's all a narrative. It's a historical narrative. And then para 6.7, so the focus is on removal of election commissioners, chief election commissioner. Therefore, after that narrative and referring to TN session, there's a recommendation at page 263 in para 6.9. These are recommendations in the context of tenure of office. And this is, of course, post 1991 Act. Then there is para 6.10.1. The Law Commission looks at the constitutional provision. Kindly turn to page 264. And para 6.10.2, the Commission notices that how Article 324(2) was left open for the Parliament to legislate on the issue. In 6.10.3, the Goswami Committee recommended a change to the appointment phrases, suggesting the CEC should be appointed by the President in consultation with the Chief Justice of India and the leader of the opposition. In turn, the CEC should be additionally consulted in the question of appointment the other election commissioner should have statutory backing. This was followed by the introduction of the Constitution 77 Bill 1990. It was introduced in the Rajya Sabha, and so providing the CEC should be appointed by the President after consultation with the Chairman of the Rajya Sabha, the Speaker of Lok Sabha, and so on and so. The CEC was further made part of the consultative process and appointed the election commission. However, and so and so, moved a motion to withdraw the bill, which was finally withdrawn to leave the Rajya Sabha on the same day. Consequently, in the absence of any parliamentary law governing the appointment issue, the election commissioner appointed by the government for the day without pursuing any consultation process. So the Law Commission thinks that a consultation process is important. This practice has been described as requiring the Law Ministry to get the file approved by the Prime Minister. They would then recommend the name to the President, that there is no concept of a collegium and no involvement of the opposition. So again, the perception that opposition must be involved, there must be a consultative process, will be important considerations which may enhance the quality of appointment process, but we're wondering whether they would be matters in the absence of any other evaluative content in the report can be ipso facto worthy of being. The commissioners are appointed for a 6-year period. I'm reading para 6.10.6. Up to the age of 65 years, whichever is earlier. No prescribed qualification for appointment, although convention dictates that only senior serving retired civil servants, the rank of a cabinet secretary or secretary to the government of India, an equivalent rank, will be appointed. The Supreme Court rejected the content. C should possess qualification similar to that of a Supreme Court judge, despite being placed on par with them in terms of the removal process. Therefore, even here, the commission does not find that there is something seriously wrong. Then the comparative practices in other countries is noticed. So 6.11.1, South Africa, then 6.11.2, Ghana, then 6.11.3, Canada, then 6.11.4. In all these cases, thus, it's clear that the appointment of the election commission, electoral office, is a consultative process involving the executive, legislature, or independent bodies. Recommendation. Given the importance of maintaining the neutrality of the ECI and to shield the CEC and election commissioners from executive interference, its imperative becomes a consultative process. And there are certain other observations made here. So kindly turn to para 6.12.2. To this end, Commission adapts the Goswami Committee's proposal to cert modification. Appointment of all the election commissioners should be made by the President in consultation with the 3-member collegium or a selection committee considering so-and-so, so-and-so. Commission considers the inclusion of the Prime Minister as important as the current government. Second, the elevation of an election commissioner should be on the basis of seniority, which is what is happening. Election commissioner with a seniority is then becomes the chief election commissioner. Then such amendments are in consonance with the appointment process in Lokpal and Lokayuktha Act, Right to Information Act, and Central Vigilance Commission Act. In pursuant to Article 324(2), an amendment can be brought to the existing Election Commissioner Act 1991 to amend the title and insert a new chapter on the Election Commission CEC as follows. So this is how the proposed suggestions are made. And appointment is chapter 1A, chapter 2A. We say the recommendations of a committee consisting of so and so, so and so. Then I'm not turning my attention to the independent secretariat, etc. They are essentially matters that dealt with on a different level. So this is how the recommendation of the Law Commission has been made. So 3 or 4 factors which emerge from here. One is the other examples to the other countries. Then the consultative process, which is probably available in the in certain other statutes. And I pick up from the Goswami Committee report, consultative process very important. So where do we go from then on? If the court were to say, this is the recommendation of the Law Commission, and if the court were then to disregard my submission that there is no evaluative content, there is something is there, but not fully to a satisfaction, regardless of that, the consultative process is something very important for the enhancing the quality of the appointment process. Therefore, it appeals to us, it commends to us that the consultative process will be taken into consideration by the executive before the appointment process is made. The court may then look at it. But before the even court looks at that, I come back to my other difficulty. This consultative process will have to be then put into the form of a law. There is a 1991 Act. The Law Commission says, have your 1991 Act amended so the consultative process can come in. So it ultimately means this law has to be amended. So the amendment of a law, we come back to our first point of time. Therefore, how do we really break ice? Is there a way of breaking the ice? So I started saying may not be seen as saying that in all these important matters, the court's engagement on policy formulations will always be issue. I'm not saying that at all. But I'm only trying to point out that there are several what called intermediate matters and issues which which matters of concern.
The right to vote, is it a statutory right? Is it a constitutional right? What is your, is it a statutory right? Is it a fundamental right? Is it a constitutional right? The right to vote as such? The matter is no longer res integra. The matter has been settled by this court. There was a division of opinion. While it is referred to as three judges bench, it was answered in 2013, 10 SEC page 1, popularly known as a Nota case. So kindly turn to that, because we have to go by that process. 2013 volume 10 SEC, it is not part of the common compilation.
I just give it.
Yes.
2013 volume 10 SEC page 1. For that, we could possibly go through that the earlier judgment in the Democratic Reforms case, that is 2002-5.
Which paragraph?
Paragraph 28.
20.
Because the question arose whether the petition under 32 is maintainable. Answering that, and with reference to the earlier two judgments in Kuldeep Naik's case also, the court proceeds to hold it is a statutory right. But then there is a facet of it which, because the freedom of expression, to know about the antecedents of the candidate without information being made available in a democracy, rights cannot be exercised.
Absolutely. There can't be any disagreement on
So
that.
there, the court said, if you just see para 28,
Para 28. 20.
you can read from para 26 because it deals with whether the petition is maintainable.
26.
Or rather, you can perhaps, you can read from
Yeah, in the earlier part of a judgment.
21.
21.
Para 21 onwards, you'll get the entire discussion.
Yeah, three-judge bench of this court comprising.
Have you got, my brother's got this? No, have you got this?
I'm so sorry. We'll have it. I'll hand it over.
This is not part of the compilation. Not part of the compilation.
I'll just get it.
You can read para 21.
So just give me a few minutes. May I read para 21? A three-judge bench of this court comprising so-and-so, separate but concurring opinions made observation as to the right to vote being a constitutional right, if not a fundamental right which reads as under. In Jyoti Basu, this court again pointed out in no uncertain terms. The right to elect, a fundamental though it is to democracy, is anomalously enough neither a fundamental right nor a common law right. It is pure and simple a statutory right. With great reverence to the eminent judges, I would like to clarify the right to vote, if not a fundamental right, is certainly a constitutional right. I stop here for a minute.
Please read on. I mean, after we'll not yet over because it's a beginning of a.
This right, the right originates from the Constitution and in accordance with the constitutional mandate contained in Article 326. The right has been shaped by the statute, namely the Representation of People Act. That my understanding is the correct legal position as regards the nature of the right to vote in election to the House of the People and the Legislative Assembly. It's not very accurate to describe it as a statutory right, pure and simple. Even with this clarification, the argument is learned Solicitor General. The right to vote not being a fundamental right, information which at best facilitates meaningful exercise of that right cannot be read as an integral part of any fundamental right remains to be squarely met. Similarly, so the right to vote, the election to House of People, Legislative Assembly is a constitutional right, but not merely a statutory right. Freedom of voting is distinct from right to vote, the facet of the fundamental right enshrined in Article 19(1)(a). The casting a vote in favor of one or the other candidate marked the accomplishment of freedom of expression of the voter. And that's the issue in this case. Except the above two paragraphs, the aspect has nowhere been discussed or elaborated wherein all the three judges in the separate but concurring judgments have taken the pain to specifically distinguish between the right to vote and freedom of voting as a species of freedom of expression. In succinct, the ratio of the judgment whether though the right to vote is a statutory right, but the decision taken by a voter after verifying the credentials of the candidate either to vote or not is his right of expression in Article 19(1) of the Constitution. As a result, the judgments in Association for Democratic Reforms and PUCL have not disturbed the position that a right to vote is a statutory right. Both the judgments have only added the right to know the background of a candidate is a fundamental right for a voter, so that he can take a rational decision expressing himself while exercising the statutory right to vote. In PUCL, how the voter's fundamental right to know the antecedents of a candidate independent of statutory rights. Under the election law, the voter is the first citizen of this country and apart from statutory rights, is having fundamental right conferred by the Constitution. And Venkatramana Reddy said, so the initial right cannot be placed on the pedestal of a fundamental right, but the stage when the voter goes to the polling booth and casts his vote, his freedom of expression arises. The casting a vote in favor of one or the other candidate tantamount to expression of opinion and preference, at that final stage in the exercise of the voting right marks the accomplishment of freedom of expression of the voter. That's where Article 19(1)(a) is attractive. Freedom of voting and the distinction of the right to vote is a species of freedom of expression and therefore carries with it the auxiliary and complementary rights such as the right to secure information about the candidates which are conducive to the freedom. In para 25, after careful perusal of the
Come to the middle of the next page because we can save time. Page 19, towards the middle of that para,
this page,
the court goes on to say, thus there is no contradiction as to the fact that the right to vote is neither a fundamental right.
Yeah, thus there is no contradiction as to the fact.
But
as to the fact that the right to vote is neither a fundamental right nor a constitutional right, but a pure and simple statutory right. The same has been settled in a catena of cases and clearly not an issue dispute. With the above observation, we hold that there is no doubt or confusion assessing the Constitution by judgment in Kuldeep Nair and do not stand implicitly overruled.
Now you come to para 28.
The decision taken by a voter after verifying the credentials of the candidate either to vote or not is a form of expression in the Article 19(1) of the Constitution. The fundamental right in the Article 19(1) read with the statutory right in Section 79 is violated unreasonably if right not to vote effectively is denied and secrecy is breached. This is how Article 14 and 19 are required to be read for deciding the issue raised in the petition. The casting of the vote is a facet of the right of expression of an individual, and the said right is provided in Article 19(1)(a). Therefore, any violation of the said right gives the aggrieved person the right to oppose this court in Article 32. In view of the aforesaid decisions as to the observation of the Constitution bill, a prima facie case exists for the exercise jurisdiction of this court under Article 32.
So we have a quaint sort of mix of principles. The right to vote per se is a statutory right. But certain aspects, facets of that right, they are part of the fundamental right under Article 19(1). For example, I have a right to vote, but I have a right to receive information, be fully informed about how I go about exercising that right. I have a right to say that I will not vote for anybody and say press a nota button.
Correct.
So the fundamental rights are actually read into the statutory right. So why we have made this effort is to bring home the fact that we may have to proceed on the footing that the right to vote simpliciter is a statutory right. Because there are three judges,
Right.
bench, unless they are able to show
Right.
something else. No, but then your woes are not an end because of that. Because the fundamental right is again read into, as we have pointed out to you, paragraph 28, the facet of how you express yourself. It's part of the right inhering in every citizen. There is a part of the fundamental right in the right to vote, in other words.
I concede.
So your objection to not, making use of Vishaga in the region of Article 324 may not be fully right, except to the extent that the right to vote per se is not a fundamental right. Second thing is the reservoir of power, which is actually, with the Election Commission of India is so wide. That's what the court keeps on saying. If you see the association judgment, court has used Vishaga in 324. But that was for the purpose of the statutory power. That association case, 2002, 5 SCC 294, Vishaga is used in para 34 to 37. Whether it could be done. But that is again, you're right there, that is again in a statutory context, not in a constitution provision.
I right. Your Lordship, sir.
But the fact remains that there is a fundamental right.
I'll try to find where one can have a little more dialogue. And I quite see.
Just
I'm thankful to your Lordship for it.
yes.
Lords, if I may,
Yes.
just for a minute, because your lordships are on this issue.
Huh.
One judgment 2016, 2 SEC 445,
Huh.
which is of Justice Chalameshwar and Justice Sapre,
That's
Rajbala versus State of Haryana.
Panchayat election.
Yes, the Panchayat
The
elections matter. From para 16 to 38, very detailed discussion on this, on the right to vote and the right to be elected, both. And there are many new judgments that they look at, but I must say that this judgment is not looked at. PUCL is not looked at, 3 judges, which they would have had to consider. But they consider the earlier PUCL 5 judges, which said it's a constitutional right.
2016,
2016, even though it was said in
Salvation,
2 SCC 445.
education codification for the.
Yes, but those paragraphs actually extract each of the paras of all the previous judgments and come to the conclusion of why it is a constitutional.
But without referring to
This is omitted. They have considered earlier 5 judges, but not these 3 judges.
This is not considered that, yes.
but that is a 2 judges bench.
Yes, yes. But Rajpal has been followed in Puttaswamy also. But again, one of the judges, not all.
That's it, but we have the freedom to take.
Of course, but I'm saying the
We are saying
interpretation.
that we are not bound
No,
by
no,
the
you're
two
not.
or the three.
Your lordships are not. Your
We are
lordships.
not.
But I'm saying the interpretation, the principles that they have enunciated and the sequence have gone through, I think that's very helpful.
Yes.
And these two judgment is laid on a constitutional bench list.
Yes, it followed relied PUCL constitution bench. That other Krishnamurthy, they said that no, Krishnamurthy didn't consider PUCL. PUCL clearly said that it's constitutional. Whereas 18 to 32.
Yeah.
Besides, my lord, our case is not merely based on the fact that right to vote and which is a fundamental right, etc. Our case is based on a larger principle of democracy being part of the basic structure of the constitution and free and fair elections being part of the basic structure of our constitution. And therefore, it is necessary that the election commission, which is in charge of elections and democracy, must be an independent body. That's
Because, the juridical premise for Visakha is there were a lot of international covenants entered into, and women had fundamental rights, and Parliament was not responding promptly, and matters were being dragging on. So they said, read with Article 142 and the power under 32, which is for fundamental rights. They said there is a fundamental right with the woman.
In fact,
That's how it is recent. That's
Absolutely.
what we have to deal
in
with.
fact, if your lordship sees prior to Vishaka, in gramophone, your lordship said there's a void on copyright law, so the Berne Convention's provisions were read in. In Vellore Citizens Forum, on environmental law, you said there's a void, so you read in the provisions of the Rio Convention, etc. You did this repeatedly, my lord. In Lakshmikant Pandey, there was void. Vishaka followed that sequence.
The matter of international covenants.
Yes.
That's a slightly different.
That's a slightly different thing.
Slightly
But
different
the
area.
question is when there is a vacuum, your
You
lordship
can read it in the case of the
Correct.
international covenant.
and the rights which are being agitated, which is why your lordship will look at this point. Because in
We are just
Vishaka,
being clear because
Yes.
it is a right to vote per se.
correct,
We cannot ignore the fact that it is a statutory right.
correct,
For example, supposing you say there is a fundamental right.
correct.
At what age do you exercise your right? If I'm a citizen, I am born.
Yes,
Okay, I'm 1 year old.
yes.
Can a 1 year old walk into the booth and say, please allow me to cut my vote?
But
I
that's
must
regulated
first
by
of all-
326 in its
Exactly.
own words, when it
That's
says
it.
adult suffrage.
Therefore, I should be 18 years.
Yes,
Correct.
yes,
Then I should various disqualifications, qualification. They're all prescribed in the statute. So they
Correct.
give the right.
correct.
The
That's
Constitution does not
No,
clothe
it
any
doesn't.
person with the right to vote.
which is why, my lords, those who are in prison don't have the right to vote.
Exactly.
Which is-
Exactly. So therefore it is a statutory right. Aspects of it, that statutory right
Absolutely.
are part of covered by 1920.
Correct, correct. And those rights, when they're being agitated by us, when we find a vacuum, your lordships will do what is necessary. If an international convention-
That is a question. That's a question how you go about it. See,
Absolutely.
What the Attorney General is addressing us is a concern
Yes,
that bearing in mind the broad separation of powers. We don't
Correct.
have the separation of powers as we have in the United States,
yes,
but we have over a period of time evolved the principle of separation of powers
yes,
in a partial way.
yes.
Because if there is separation of powers, we wouldn't be having 356.
Absolutely.
There is one example where
Yes.
in the earlier judgment of 62 Supreme Court, they say, no, it's not a case of pure separation of powers, partial level.
Yes.
We should not, overreach our boundaries.
No,
When we
absolutely.
say that that's the only concern, we should carefully address that.
No, correct.
Otherwise, he has pointed out number of statutes, number of provisions in the Constitution where they say subject to law may be made.
We'll show you how those are distinguished.
They are distinguished.
And there
That's a
are
different-
categories into which they fall.
No, what you're saying is the restraint should be there. When we
Yes.
say that we should not jump at the idea and say, okay, here we are.
Even I,
Visakha,
In fact, since your lordships are looking at it right now, just see. There are only 4 provisions in the entire list that the AG gave you, which says specifically with reference to an appointment subject to the provision of law. Which are those 4?
they can
324, I'm just telling your lordships, 324, 338, 338A and 338B, which were recently introduced. Because the Commission for Backward Classes, SC, STs, etc.
We say that point.
Your lordship, see that.
That we can.
So that those stand separately.
What you're really saying that when we are, this is a 5 judges.
Correct, correct.
and not easily,
No, no,
we have to
absolutely.
have a 7 judges.
Absolutely.
If we go wrong.
Absolutely.
We have a
We can
great
settle these.
duty to be very right,
Yes.
to be correct.
Correct.
It's not that, we write something
Correct.
and then it has to be reconsidered after 2 months. You have to be careful. That's all
No,
that.
but
I say.
equally
Whatever we do,
important-
whichever way decide.
Well, it's equally important is that we have an opportunity to settle peripheral issues which have agitated this court in a series of judgments.
Absolutely.
So if
No,
the
don't
right to
forget-
vote being a constitutional right, your lordship, we are settling.
Besides, my lord, we are asking for something which was similar to what was asked and done in Prakash Singh or Vineet Narayan. There were no international covenants. The
No.
court proceeded that because the police needs to be somewhat independent from the executive. Otherwise, it destroys the rule of law and it threatens Article 21 rights of citizens. Therefore, and they said that several commissions have gone into this and they have proposed various reforms to do this.
Correct.
Government has not done it. Therefore, now we are going to order it till such a law is made. Same thing we are asking in this.
So there is another thing.
One
I'm
short
just
point I may
taking
make.
up from where Mr. Bhushan left it. See, Article 14. Perhaps we have a role to play. Because the state, parliament is also an organ of the state. Obviously, it's making laws. It throws up the very peculiar position where the refusal by parliament to act. And that brings up your question as to whether you can injunct parliament by a mandatory injunction or a mandamus. Please make a law. We cannot do that. But then that leaves us with the question as to whether your inaction can be treated as arbitrary in the peculiar set of facts in the conditions obtaining in our country. And we gave you in 8 years,
Yes.
8
I follow.
So it is basically, it's all, you can't be running to England, to US, and then borrow everything lock, stock, and barrel and, plant it here because as somebody said, it'll become poisonous.
Very
You
true.
plant every idea, without bearing in mind what happened, what kind of people we are. What is the character we have? Whether we have any left? Where have we reached? What are we doing? It's common sense. Ultimately, law is common sense. You can argue and argue and argue. Finally, what do we get on the ground? Do we get somebody with, say, less than a year on a perennial basis? So it's a mockery. If it is a mockery, what are we doing? What can we do? This is what we are seeing. Yes.
One short point I may make, Lord, in addition.
Alicia, let the attorney complete, otherwise, it will not go on. Yes.
So in apropos what your lordships are putting to me in the other judgment, in the Rajbala judgment, and after stating the proposition and raising the concern in paragraph 28, in that judgment, court goes on to consider how it is important for the freedom of expression. So now it is no longer at the stage of a mere right to vote, but when you go to vote, what do you do? So it's a different, arena altogether. And it's occupied by a fundamental right. That's what the court has said. I think that's important. I think you did not even have a debate on that. And then in Rajbala, even if it is not considered, the question was whether you were disqualified. Even if a right to a freedom of expression in 1918, that may have no basis of connection as far as disqualification is concerned. The state may have several considerations why somebody may not contest election at all.
Then you just bear in mind that this is not an ordinary statutory right. There are
The right to contest.
It is a right which is, very intimately interconnected with fundamental rights.
Correct.
And what is more, it is most important aspect is it is very integral part of the basic feature which is democracy. That's why we told you at the very beginning. You have to have a premise which is not simplistic, as you very correctly point out. There is no simplistic formula here. It has to be premised very carefully. Otherwise, what will happen in future generation of judges?
Lordships are right. So I'm trying to imagine a triangle. Now we have basic structure on the one hand, then the constitutional rights, then a statutory dimension of a right, things like that. You try to look at them. They have intimate connections. They may have some connection somewhere, but because they are connected, will there be a further debate on I have a whatever right of freedom of expression 19(1)(a), and that perhaps can be subject to any restriction or an impediment by reason of electoral process. An electoral process which impedes that, one can understand that. But we're not an electoral process impeding that fundamental right.
Not that.
Ah.
See, the point is the position of the chief election commissioner and the election commissioner.
Right.
The word superintendents, the three magical words in Article 324, have been found to contain
Yes.
a limitless reservoir of power, responsibilities, duties, and those duties are shouldered by the fragile shoulders of three men, flesh and blood. They are there. They will actually, be the sort of fountainhead on which the rest of the army of, the officers, their staff, they will decide. You have a session once in a while. I can just recall, in an interview, he says that he was a cabinet secretary. So somebody said that, the Prime Minister has said he wants an election to be held, declared on a particular day. So he said, I can't go and tell the Election Commission to declare the election on a particular day. That is a call to be taken by the Election Commission. I respect his independence. I'll never go.
Correct.
And he would not entertain anyone who would go to him. So that kind of a man we want, not the political party. Let it be any political party. None of us are concerned with any political party. Let it be any political party. What is important is we put eternally, immutably a system in place. We already have done fairly well under some of these election commissioners. We have put in place fairly good procedures which are also equally important. But the choosing of that man, at least last 20 years, we have pointed it out to you with examples.
I'm trying to get back on that.
Yes. So this is a very, very, what Dr. Ambedkar said, it is going to be the biggest headache. The extraordinary powers of prescience. He knew where we are headed. And we have reached there. Because he takes, the point is, there are any number of, any number of situations where the independence, the character of the man is what is most important. Competence is there. Is he competent? But the man has to stand up that I will not allow anybody to bulldoze me. I will take an independent decision, impartial to all political parties. I will apply the rule to everyone equally. If the Prime Minister, whoever in the ministry maybe who tries to, influence me, I don't care two hoots about it. So we need such men. So the point is only this: who will appoint such people? Because the most important person is the man. But how do you get to that man?
Yes.
You have to have somebody who will appoint him. So that is why
I see the connection. I see the connection.
That is
there's a logic. I don't think we can have any digression on that question.
So one more small, I will just, because otherwise it will go on. The point is, the least intrusive of all these models appears to be the Chief Justice of India is a party, like in the case of a CBI director or whatever. Lokpal also. The Chief Justice, the very presence of the Chief Justice. An independent Chief Justice comes there and he says, the very presence will be sort of the message that you can't be playing, games with, the appointment. You will not allow it. You'll need to pick up the best man. Very simple. Pick up the honest, best man, character, man of independence. See, they have to, in some other countries, they have to file affidavits that they don't have any political affiliation. They were never associated with any political party. At least to the extent that our human institutions can endeavor and produce the best. We should try to do that. I don't think as Attorney General you would oppose that.
I don't think to have best people in all institutions.
Absolutely.
I don't think anybody should have any objection.
Exactly.
I don't think even the government should have any objection.
Exactly.
It enhances the quality of governance.
Absolutely. Future generations will look back
But
to this moment where, you know, this expression of yours will go a long way.
I had only one thing.
you lost.
We all are on, at least on one question, we are all common.
You lost.
If we must select the best. Now, how to select the best, that is the question. And where to find out. And whom we should trust. Either a committee, some mechanism, fair committee, fair mechanism, transparent mechanism. Everyone is facing this problem.
You lost.
Just to broaden that aspect, see, in Pakistan, our neighboring country, got independence the same time, 1956. They have a system where it's a multi-member chief commissioner, as they call it, and election commissioner. If you see that, you know what I've given.
Yes, sir.
They have provided that the other commissioners should be retired High Court judges. See, retired High Court judges, we know that subject to, as my learned friend said, who selects and who is selected. Generally, we can expect a level of sort of proficiency, competence in that particular field, where they will bring to bear on this huge responsibility, the experience, their independence, their training as judges. What is it that we are all with prejudices, all of us have prejudices, but it is all hemmed in by the training. What we are told, you know, okay, you decide according to a particular rule. You don't decide according to that rule. Don't look at the face of the man. The same principle will apply. So here what is happening is, for the last 40, 70 years, mostly bureaucrats.
I'm trying to find
Brother
out.
Roy, we just wanted to point out to you, there has been one woman chief election commissioner.
Rama
Devi, for the very short period of 70.
I think that's some systemic fault elsewhere.
So if you want to select the best, the selectees must also belong to that class, the best. Otherwise, what would be the problem?
I don't think any party to this debate, including the government, will have a disagreement on that question. I don't think I'm raising that issue at all. The best person to be part in charge of the affairs of any institution is the highest guarantee that the institution will function and then be able to realize the purposes of the institution. And there's no difficulty at all. But I was only trying to find out how we actually look at it in the context of this case. You can say, well, your lordship may reject my submission that there is no connection between the perceived independence of the election body and the actual right to vote or a right to participate, because there doesn't seem to be a concrete situation where this has impeded the right to vote or the right to express. So therefore, that submission may or may not be rejected. It can be even accepted. But the court were to go further, yes, I don't see a connection between an independent election body not being in position, and therefore there is a shadow is cast on the freedom of exercise of, voting, etc. And then, of course, position will be different. But if you look at certain other broader pictures, like, well, it is not a fundamental rights question because no fundamental rights violations are made out or not even involved, and you can't even perceive it. So the question is there a basic structure question? An independent election body, etc. Then we enter into a different level of a debate. So when every constitution, that's why in Indira Narayan case, they said, look here, it's a slippery slope. How do you add? We've added, brick after brick into the basic structure, only for the purpose of enhancing again just the intrinsic strength of the constitution and its being alive. But when you want to have a debate on the basic structure, then we go on a different level. So then it must be shown that it affects the basic structure. There must be a law or must be an action which affects the basic structure. So basic structure is always a question where there is an exercise or an attempt to invade the basic structure or affect it. then only we enter into that question. A mere silence, that's why I said in this case, what the court is being asked to do is perceive there is a vacuum or a gap because Parliament has not enacted so far on the subject. And then we look into the vacuum or the gap and said what others have said about it. Now I will try to look at the gap or the vacuum, and therefore, if that vacuum or a gap, take it to the next level. I say it affects the basic structure. Then we are entering into some, circuitous process. That's why I said if the original provision of the Constitution affects the basic structure. So there is some difficulty in entering into those areas. And both Vineet Narayan and Vishaka. No, from the company. Vineet Narayan is there. Give me Vineet Narayan. Vineet Narayan is not in the compilation.
The Wikipedia is very formidable. You set up not what fell from my mouth.
It is not in their compilation. Wait.
1998.
That you wanted to.
Lords can pick up Vineet Narayan.
Yeah.
Excuse me.
Paragraph 3 at page 234. Just above that, in para 2,
Yeah.
just about placitum F so and so, we must also record our appreciation of the office of the CBI in the Revenue Department, who actively participate in this proceeding and showed a definite improvement in their perception of the rule of law as the case progressed, and their ability to perform improved once they were assured of protection in the honest discharge of their duties. This experience revealed to us the need for the insulation of these agencies from any extraneous influence to ensure the continuance of the good work they have commenced. It is this need which has impelled us to examine the structure of the agencies and to consider the necessary steps which would provide permanent insulation to the agencies against extraneous influences to enable them to discharge their duties in the manner required for proper implementation of the rule of law. To focus on extraneous influences. And then permanent measures are necessary to avoid the need of every matter being brought to the court by taking ad hoc measures to achieve the desired results. This is the occasion for deal with the structure, constitution, and the permanent measures necessary for having a fair and impartial agency. The faith and commitment we all concerned in this proceeding is the surest guarantee the survival of democracy with the rule of law is the bedrock. In the next paragraph. 4. Brief narration of the facts is case necessary, and so alleged to be an official of a terrorist organization arrested in Delhi consequent upon his interrogation. Raids were conducted by the Central Bureau of Investigation, brothers, relatives, along the Indian foreign currency CBS seized 2 diaries and notebooks. The premises they contain detailed accounts of vast payments made to persons identified. Initials correspond to the initials of various high-ranking politicians, in power and out of power, and the high-ranking bureaucrats. Nothing having been done in the matter of investigating the Jains and the contents of the juries, the present writ petitions are filed in the public interest under Article 32 of the Constitution of India. And the gist of allegations are said in paragraph 5. Kindly turn to paragraph 8. In para 7, they are talking about the political personalities investigated in the Jain dairies. Then we have taken the view, given the political personalities, it was advantageous not to hear the matter through an issue writ of mandamus, leaving it to the authorities to comply with it, but to keep the matter pending while the investigations are being carried on, ensuring it was done by monitoring them from time to time and issuing orders on behalf. They are referring to a large number of orders. Then para 8, summons substance to these orders, the CBI and other governmental agencies had not carried out their public duty to investigate the offences disclosed. That none stands above the law so that an alleged offence by him is not required to be investigated. That would monitor the investigations in the sense that you do that permissibly. What we permissibly could do to see that the investigation, the progress, while yet ensuring that we did not direct or channel the investigation or in any other manner prejudice the right of those who might be accused or to stand trial. Made it clear the task of monitoring court would end the moment the charge sheet is filed and all that. Then comes paragraph 9. Even after this matter was brought to the court complaining of the inertia of CBI and other agencies to investigate the offences because of the alleged involvement of several persons holding offices, for quite some time the disinclination of the agencies to proceed with the investigation was apparent. The accusation, if true, revealed a nexus between high-ranking politicians and bureaucrats and who were alleged to have been funded by a source linked to the source funding the terrorists. In view of the funding also, the foreign currency, some undesirable foreign elements appear to be connected. This revealed a grave situation, posing a serious threat even to the unity and integration. The serious threat for the Indian polity could not be understood. The obvious need for an expeditious and thorough probe, which already been delayed several years, could not be counted. That is how the court proceeded to put its in a hand further in this matter. Then paragraph paragraph 15, they note at page 243, inertia is the common rule whenever the alleged offender is a powerful person, necessary to take measures to ensure permanency in the remedial effect to prevent reversion to inertia of the agencies in such matter. That is one of the anxiety. And paragraph 17. As a result of the debate in these proceedings and the experience gained thereby, the Union of India came to realize that an in-depth study of the selection of personnel of these agencies, particularly the CBI and the Enforcement Directorate, the Revenue Department, their functioning is necessary. Government of India, sharing this perception by an audit its own, so constituted a committee headed by the Home Secretary to take stock of all available information about the activities of crime syndicates, mafia organization, developed links and so on, etc. Then at Placitum C, the committee was headed by the Home Secretary Vora and members so and so, so and so. Then recommendations dated 5/10/1993. It has made scathing comments that has painted a dismal picture of the existing scheme. It says the network of the mafia is virtually running a parallel government pushing the state apparent irrelevance. Committee recommended the creation of a nodal agency, Ministry of Home Affairs, for the collection. I proceed to read it. So we have this committee, and then thereafter, you've got to find at Placitum D, the report of the Vora Committee's opinion, some top bureaucrats confirmed there were suspicions focusing need to improving the procedure for constitution monitoring and functioning. In paragraph 18, the same perception of the Government of India led it to constitute another committee by order dated so and so, and called the Independent Review Committee. The order reads as follows. Then the remit to the committee is at page 245. At the terms of the reference, that particularly the para 2 examine the present structure and working of the Central Bureau of Investigation Enforcement Directorate and related agencies suggest measures if needed to ensure so and so any person, particularly those in by authority, are registered, investigated, prosecuted fairly, expeditiously, and without inter alia against external pressure, ensuring adequate protection to the functionaries. Then B, there are sufficient checks and balances to ensure that the powers of investigation and prosecution are not misused. And C, no arbitrary restriction on the initiation of the investigation. law, and
Mr.
prosecution.
Attorney,
Then comes,
why this court step in this matter?
no, I want
Why this
to,
court step in this matter?
uh,
The reason forthcoming was
yes,
at a given point of time, there are a good number of politicians who are under the arena of investigation. Maybe some cases. CBI was the agency who had to investigate. This court felt, and we also know the ground realities. The court wanted that CBI must independently investigate all matters, regardless of the fact who politician and who may be. The procedure for appointment of director was still there. It's not that it was not there earlier. And only after this court step in, the mechanism has come forward for appointment of a director. But the court felt no, that mechanism may not be fair in dealing with the nature of matters which are coming up for the CBI to investigate. Let us put in place an independent agency in making an appointment to hold the post so that an independent investigation, even in the cases of politicians who are coming forward at a particular point of time, they also have a fair nature of investigation. That's why this court step in. Otherwise, minus Vineet Narayan, as there was no provision how to the director of CBI to be appointed. There was a provision.
yeah.
And appointments were made.
Yes.
Nobody questioned it. This court also never stepped in.
Let me read how the case progressed thereafter.
See the initial paragraph itself.
Yes, all right.
This court has disclosed why we are stepping in.
Let me try to pick out a leaf from
There
this
are
case.
7 or 8, I think.
I'll just come to para 26. I'll just come to that. The need for insulation of these agents
Yes.
from extraneous factors which may deflect the fairness of investigation and therefore entirely compromising the investigation process.
Correct.
Regardless of whoever they are who are in deflecting the investigation process, if that's going to actually reflect, the court says.
How to insulate this post of a chief election commissioner?
I'll just point out what happened in this case. Little further. I find from the report that they appointed an independent review committee. The independent review committee came with a set of recommendations. And the recommendation of the independent review committee has been accepted by the court. Virtually, whatever were the recommendation of the independent review committee has been simply endorsed by the court. The court has not independently taken an analysis of the recommendation, entered into their evaluation, and the need for ABCD to be accepted, EFG not to be accepted. No. The entire set of recommendations, which emanated from the experience of those who were in the committee, being party to the civil service. They've been there for long. So therefore, this is a case where those recommendations, without any further elucidation or evaluation, the court simply said this can be accepted. Kindly turn to paragraph 25 at page 249, and thereafter.
What do you suggest? In this matter also, we should constitute a committee to provide us inputs for taking a final decision in the matter.
No, I'm not suggesting. I'm only saying that look at the facts of that case. I'm not saying there can be a circumstance when there is no committee at all. I'm just in the abstract. Suppose there's no committee, there's no inputs, but a violation of fundamental right is brought to the notice of the court. Then what is it the court will do? The court will ask for inputs in order that this is how the violation of fundamental right takes place. And those inputs will be essential inputs for comprehending how to avoid a violation, how to avoid a breach of a fundamental right. then the court will be in a better position to go into that exercise. So therefore, I said this is a case where there was a set of recommendations which was simply accepted by the court. There's no evaluative criteria, there's no further consideration.
Court also considered at the subcaption, the caption to page number 255, the need for court's intervention. Here also that is very relevant. The need for court's intervention. Whether that is there or not, that is the first question. At page 255.
Page 255.
Then the power of the court, that was also another subheading, the power of the Supreme Court. So these aspects were considered.
Correct. Absolutely.
So here also we will have to consider the need for court's intervention, whether that is required, and then the question, the power, to what extent.
Absolutely right. Because that's why on the facts of that case, if the government itself felt there is a need for looking into it and gave a set of recommendations, the importance of it is being underlined by the court. There's an emphasis given by the court to say, yes, we see the importance. If the court has not intervened, what would have happened is anybody's guess. Whereas the IRC recommendation would have remained, but the IRC came in the course of all the deliberations. It happened like that. So in the course of the deliberation, there is something available before the court. So that makes it again a concrete situation when the court is in a position to enter into even a minimal evaluation or a minimal consideration. Therefore, Vineet Narayan stands in a slightly different footing. And I say the need for court intervention, before we say that, in paragraph 25 at page 249 onwards.
In this case also that should be considered, the need for intervention.
No, I'm not anyway disputing on the need for intervention. I don't think anybody would have said that. What I'm saying is on a slightly different dimension. Page 249 to 255 are the set of recommendations which the IRC has placed before the court. Those set of recommendations you'll also still find after 255. At page just about the need for just above paragraph 26. Reference to paragraph says so and so, containing discussion pertaining to the Central Bureau of Investigation, Central Vigilance Commission, Directorate of Enforcement in Part 2, recommendation therefore to be read along with discussion in the corresponding paragraph. Then in paragraph 26, immediately after Placitum E, when the report of the IRC is set out, just above Placitum F, there can thus be no doubt that there is a need for the exercise you are called upon to perform. And this is occasion consideration of crucial issue with the court exercise powers conferred by the Constitution of India. The conclusions reached by the IRC and the recommendation it has made for improving the functioning and thereby the image of the agencies is a further reaffirmation of the general belief. No doubt that the conclusion reached by the IRC and recommendations are the minimum which require immediate acceptance and implementation of it to any further delay of the polity. Exercise to be performed by the court is really to consider any notifications required to make the recommendation of the IRC for achieving the object for the central government itself constitute IRC. We informed by the Attorney General for the action report IRC could not be taken so far because of certain practical difficulties faced by the central government. But there's no negative reaction to the report given by the central government. So that is why the court proceeded to, yes, we give our imprimaturs. In paragraph 48, in view of the page 264, in view of the common perception shared by everyone, including the Government of India and the Independent Review Committee, the need for insulation of CBI for extraneous influence of any kind, it is imperative that some action is urgently taken to prevent the continuance of the situation with the way to ensure proper implementation of the rule of law. Therefore, here is a common perception which was the basis for the court to proceed further. Then turning over to paragraph 53 at page 266. I'll come back. On this basis, we now proceed to give the directions enumerated hereafter for rigid compliance till such time the legislature steps in to substitute them by proper legislation. These directions in Article so and so implement the rule of law wherein the concept of equality is embedded as the force of law under Article 141, so and so, etc. Judicial Territory of India to act needed to the court. Then 54, before that, we have accepted and are reiterating as far as possible the recommendations made by the IRs. And the standards in public life, then come to paragraph 58 at page 269. So these recommendations you all look at paragraph 58 are virtually a verbatim reproduction of the ARC recommendations.
Yeah.
And why did the court ultimately say I have this 32 read with 142, and court cites examples in paragraph 51 at page 265. It says in exercise of the powers, 32-142 guidelines and directions have been issued, large number of cases, and brief reference to few of them is sufficient. So Kanga with Union of India, Constitution is laid on certain guidelines relating to Immigration Act, Lakshmikant Khande, guidelines for adoption of minor children, then Sampath Lal, Veeraswamy, etc. Guidelines were laid on having the effect of law requiring rigid compliance. For instance, Skipper construction was a real estate issue where you violated the law, breaches of law. And then advocates in the court association, the 9-judge bench, the appointment transfer of judges, which are being rigidly followed matter of appointment. So and so. More recently in Vishaka, elaborate guidelines have been laid on for observance in workplaces relating to sexual harassment of women, so and so. Vishaka, we said, the obligation of this court under Article 32 of the Constitution for the enforcement of these fundamental rights in the absence of a legislation must be viewed along with the role of a judiciary envisaged in the Beijing Statement of Principle for the independence of judiciary in the Asia region. These principles are actually the chief justice of Asia and Pacific Council in Beijing, as those representing the minimum standards necessary to be observed in order to maintain the independent and effective functioning judiciary. The objective judiciary mentioned Beijing Statement of so and so. And after setting out that, then there's an exercise of this kind. But the court is now a well-settled practice with a second firm roots in constitutional jurisprudence. Exercise essentially fill the void in the absence of a suitable legislation to cover the field. So that proposition will always be subject to adjustments, modifications, qualifications, and caveats. So when you draw it so over broadly, and we want to apply it in a particular situation, then court will always ask this question. Is there a legislation which is contemplated? Or it is generally the constitutional obligation to cover a field, to be proactive under the Constitution, and therefore protect fundamental rights. That's where Vishaka comes in. So if you're not proactive and protect women in the workplaces, I just want to digress here for a minute. After Vishaka, there are two petitions are filed, one in Delhi High Court, one in Supreme Court, on guidelines you framed as far as courts are concerned. And guidelines were framed, Mr. Nariman was involved in that, guidelines were framed. And those guidelines were prior to the 2013 Act being enacted. And after the Act came into force, question arose whether these guidelines framed were in consonance with the Act or not. I happened to be heading a committee asked by the court to give a report to the court on that issue. I found there is some dissonance between the guidelines and the act, particularly because the peculiar nature of a court as a workplace and how to really you adapt those set of principles to court as a workplace. There were some issues. I've given a report. It's still pending with the court for consideration. Why I want to say this, there can be occasions when you move forward, a law comes in, but still there are unattended issues or unexplored dimensions of an issue, which may still call for an understanding and moving further. So therefore, why I want to draw this example is we have a situation on hand where the question is not merely answered by saying there are these kind of recommendations are there. We find that over a period of time, that the process of appointment or the persons who are being selected and how they really serve the institution, there are some issues or questions which seem to be emanating. Therefore, on those perceptions, we find that we say there is a mandatory obligation for the state to move into this. That is where I keep encountering some difficulties in saying, yes, this can be done, cannot be done. So, Vineet Narayan may not be a clear and a direct proposition to say that the court will do, because here, except those, to equate the IRC recommendations to, Lordship.
The point you are
Yes.
laboring to make is,
Yes, yes.
and which perhaps we may have to get a response from them. We need in Vishaka, paragraph 16 of Vishaka, the court says, in view of the above and in the absence of enacted law to provide for effective enforcement of basic human rights, etc., we are issuing guidelines. In the case of Vineet Saran also, the court of course went ahead and said it must be made a statutory right, an extraordinary
Yes,
thing to do.
Right.
What you're saying is that in a constitutional provision in particular, when the founding fathers have provided for the mechanism for appointing the chief election commissioner and the election commissioners, there is no vacuum, because the president means the council of ministers. Now, as to whether it is a satisfactory state of affairs, that could be a more ideal state of affairs, a better state of affairs, debatable. Whether that will provide us with a scenario which is similar or identical with Vishaka, no.
I understand.
No.
Understand.
So therefore your argument is really there is no vacuum.
That's right.
In which the court can't really step in.
Right.
Unless we say that we are going to rewrite Article 324(2) in a manner to speak.
That's
Supply and omission, causes omission, which
that's right. That's
the law is that ordinarily we shouldn't be.
You're right. Right.
So we are stepping in on, like you said, idealistic content, aspirations.
That's why I use the word aspiration. I'm using it in a very, very highest level of its content and meaning.
No vacuum. You're basically, there is no vacuum.
Right. And that could be a good aspiration. I don't think one can even debate about it. So that's where the line of demarcations may.
I'll answer that whenever your lordship wants to. There's a straight, simple answer.
So the moment he completes it, he put it to the side. Yes.
See, there is just a slight digression, because you're talking about 19(1)(a) expression, etc. That Cards case where eavesdropping, US Supreme Court were called upon to decide whether electronic eavesdropping would be an invasion of your, injunction against searches and seizures. So the Fourth Amendment to the US Constitution said illegal search and seizures are prohibited. So Cards went on to decide eavesdropping is well known, but electronic eavesdropping, is it a search or a seizure? The majority went on to say the Constitution provides persons and not places. That's how they answered that question. Justice Black in his dissent says, no, you can't look at a perceived constitutional silence there and therefore try to give a meaning which the constitution makers did not even contemplate.
That's right.
So a perceived constitutional silence can sometimes be a very debatable area. That's where both Vineet Narayan and Vishaka are not in that category at all. There's a women's right and dignity at workplaces, and is a matter of immediate action, urgent action. It can't prove delay, and we can't fall back merely on a constitutional reading of Article 21. We need some effective working machinery. Therefore, there is a need to fill up that immediate need. That's how Vishaka came in. I also keep wondering, after Vishaka, the court has gone further again on what called exercising its constitutional deliberative engagement only with a view to ensure that fundamental rights get their due. So beyond that, in order that the court enters into that kind of an exercise, there must be to repeat, I'm sorry, I'm repeating, there must be a live connection between the issue and the fundamental. So that's why paragraph 16 takes care of that. I just come back to Raja Rampal for a minute. This is 2007, 3 SCC 184. This was Article 105.
Privileges.
Immunities, powers, and privileges for the House of Legislatures. A long debated issue, both, and then from Keshav Singh onwards.
House of Commons. Finally, they say this House of Commons power is there. That's
Sorry.
it'll be the same.
So the Constitution bench in this matter kindly turn to. Let us look at page 239, some of the factual background. Page 239. What is the context in which this issue came? 239. The interpretation of Article 105 of the Constitution of India is an issue in this matter. Question is whether in exercise of the powers, privileges, and immunities contained in Article 105, or the Houses of Parliament competent to expel their from are competent to expel their respective members from membership of the House. If such power exists, is it subject to judicial review, and if so, the scope of such judicial review? The unfortunate background in which the opposite questions were written in the allegation. Members of Parliament indulge in unethical and corrupt practice of taking monetary consideration and in relation to the functions of the MPs. A private channel telecasts a program so depicting 10 MPs out of people in the council of so-and-so, accepting money directly or through a middleman as consideration for raising certain questions, or otherwise espousing certain causes for those offering the lucre. This led to the extensive publicity in the media. Presiding officer of which Parliament instituted inquiry through separate committees. Another private channel telecasts a program alleging improper conduct of another MP so-and-so in relation to the implementation of the Parliament Development Scheme. Incident also referred to a committee. Then report of the inquiry concluded the evidence against 10 members of the Lok Sabha was incriminating. The plea that the video footage was doctored, morphed, edited at no merit. There was no valid reason for the committee to doubt the authenticity of the video footage. The allegations of acceptance of money established acts of acceptance of money, direct connection with the work of the Parliament, and considered such conduct on their part as an unbecoming member of the Parliament and also unethical and calling for strict action. Then, little later, Placitum G, the majority report recorded the deep distress over the acceptance of money and for raising questions now, found it eroded the credibility of Parliament, the institution and pillar of democracy, and recommended expulsion of the 10 members. Then paragraph 5, next page. On the report of the inquiry committee being laid, a motion was adopted the Lok Sabha resolving to expel the 10 members in the membership, accepting the finding as contained in the report of the committee, the conduct of members was unethical and so and so. On the same day, Lok Sabha Secretary issued an impugn notification notifying the expulsion of the MP, so and so. Then The almost similar process adopted undertaken in Rajya Sabha, matter referred to the ethics committee. Then the committee found member had accepted money for tabling questions, and that's how then para 7 report the ethics committee was adopted to the Rajya Sabha, and the notification notifying expelled member was issued, and that's how the matter came to the court. Para 9. The two members of the Rajya Sabha have also challenged the constitutional validity of the expulsion article 105 is as follows. Then there is para 10, identical provision 194. Then paragraph 13, their contentions at page 242. The petitioners submitted all the powers, privileges, and immunities that vested in the date of commencement of the Constitution of India in the House of Commons and so on, so had not been inherited by the legislature in India under Article 105 of the Constitution. Main contention urged that the power and privilege of expulsion is except by the House of Commons as a facet of its power of self-composition, and since such power of self-composition has not been given by the Constitution to Indian legislature, it did not inherit the power to expel its member. The contention is that the expulsion is necessarily punitive in rather than remedial, and such power vested in the House of Commons as a result of the power to punish for contempt. In its capacity as the High Court of Parliament, since the status was not accorded to the Indian legislature, the power to expel could not be claimed to the House of Parliament under Article 1053. It's also their contention the power to expel cannot be asserted to Article 105.3 also for the reason that such an interpretation would come into conflict with the constitutional provision. A grievance has been made about denial of principal naturalization, inquiry proceeding, the gross and patent illegalities, and so on and so forth. Then, just after Placitum C, the petitioners submit at page 243 that the constitutional and legal protection accorded to the citizens would become illusory if left to the organ in question to determine the legality of own actions. They further submit it's also a basic principle of law, rule of law permeating every provision of the Constitution. Rather, forming its core essence that the exercise of power by the executive authority must not only be conditioned by the Constitution but also be in accordance with the law. In this context, it is primarily the function of the judiciary alone to ensure the law is observed and there is compliance with the requirement of constitutional provisions. Then paragraph 16, it is a petitioner's contention. House of Parliament had no power of expulsion of sitting a member. They plead the petitioners could not be debarred from membership by an order of the impugn notification pursuant to the proceeding consequent upon the media reports, in as the substantive and adjective law had been disregarded, and the constitutional inhibition placed in the exercise of power of debarment had been defeated. On the case that Indian legislatures cannot claim the power of expulsion members, the contention stated this. Then just look at the legislature has no power to expel members since Parliament has not enacted any law which provides for expulsion of member in a specified circumstance in terms of an enabling power to legislate on the subject as available in Article 105 of the Constitution. Then 3, they're talking about no provision either in the Constitution of India or in the rules of procedure and conduct of business for expulsion of member by adoption of a motion under the Impeachment Act beyond the jurisdiction of Parliament.
Yeah.
Paragraph 36 at page 249. Having given our anxious consideration to the myriad issues that have been raised on both sides of the divide, we have found that the primordial question that need to be addressed by the court can be formulated as under. Does this court within the constitutional scheme have the jurisdiction to decide the content and scope of powers, privileges, and immunities of legislators and members? If the first question is answered in the affirmative, can it be found that the powers and privileges of the legislature in India, in particular with reference to Article 105, include the power of expulsion of members? In the event of such a power of expulsion being found, does this court have the jurisdiction to interfere in the exercise of said power or privilege conferred in the rules on Parliament and members of committees and so, and if so, the jurisdiction circumscribes certain limits? Then kindly turn over to page 250, paragraph 43.
Yeah.
As can be seen from the language employed in Article 105, Parliament is empowered to define by law the powers, privileges, and immunities of each house and the members and committees in respect of other than those specified in the constitutional provision. Though some part of the arguments advanced before the petitioner did try to refer to certain statutory provisions. For example, provisions contained in sections 8, 11 of the Representation of People Act as referable to the enabling power given to Parliament in the first part of Article 1053. But for present purposes, we assume that Parliament has not yet exercised the said enabling power, in as much as there is no law enacted till date that can be referred to as cataloguing the powers, privileges, and immunities of each House of Parliament and the members and committees. This consequently lead to the continuity of the life of the second part of Article 1053, in as much as that part of the provision was designed to come to an end as soon as Parliament defined by law its powers, privileges, and immunities. Therefore, powers, privileges, and immunities not having been defined, the question as to what are those powers which are enjoyed by the House of Commons at the commencement of a constitution, that will determine the powers, privileges, and immunities of both houses of the Indian Parliament. Therefore, in a context like 105, we did not prove delay. And if it is a transitional provision, so you don't look back to the House of Commons or whatever available in England. So even in that context, if Parliament has not enacted, what should happen? Was the anxious consideration before the court.
But the court was not invited to, supply any vacuum or, that was not the issue there.
I know, but I thought it's important just to have place it in its position, that's all. So if your comparison with 324(2) and 105, if it is opposite, then there is something to be drawn from this judgment.
No, but what conclusion you want us to draw from this authority?
This authority, we want to say, kindly turn to para 166.
Yes.
The court, even after noticing the importance of the need for a parliamentary intervention in this matter, to define the scope of powers, privileges, and immunities, which are as equally important for the purpose of Article 14, Article 19, 1A, and even maybe Article 21 in current point of thinking. Even if in that context, if there is no law, Parliament has not intervened, the court did not think
Court
go
cannot
far.
direct Parliament to.
That's right.
Yeah.
Therefore, I'm only drawing a parallel between the importance of that constitutional provision and that constitutional scheme vis-a-vis 324(2). I don't think we can have something on a different pedestal. Both are equally important. I'm not saying that the higher importance is the lower.
The privileges enjoyed by the members of the House of Commons.
That's right. Therefore,
So
the court felt there is no vacuum.
There is no vacuum.
There's no vacuum.
That is the point. That is the distinction.
So paragraph 166 at page 289. First, it is to be remembered that Article 1053 is itself a constitutional provision, and it is necessary that we must construe the provision in such a way that a conflict with other provisions is avoided.
Yes.
We are of the view that where there is a specific constitutional provision as may have the effect of curtailing this fundamental right, if found applicable. If found applicable, there is no need for a law to be passed in terms of Article 19(6). For example, Article 102 relating to disqualification provides that members who are of unsound mind or on undischarged insolvency declared by competent court are disqualified. These grounds are not mentioned in the Representation of People Act 1921. Though this provision would have the effect of curtailing the rights in the Article 19(1)(g), we doubt that it can ever be contended that a specific law made in public interest is required. Similarly, if Article 1053 provides for a power of expulsion, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make law on this subject is no reason to say that a law has to be mandatorily passed when the Constitution itself provides that all the powers of the House of Commons rest until such a law is made. A question may be put to me that, well, there are some existing safeguards available, we borrow it from the House of Commons, therefore there is no vacuum. But here we find that the process of appointment throws some doubt about whether this would be the most ideal way of going about it. Therefore the connect may be little maybe a little open to question. Your Lordship may put the question to me. I am bound to answer that. But I thought just to draw those conceptual
Yes,
parallels are important.
You have understood.
I only try to draw that. I would take your Lordship through some of the judgments. Before I do that, maybe I think I can continue tomorrow. I wanted to give some information on the Law Commission issues, how many reports. There's some information. I'll put it on a small note and give it to your Lordship tomorrow. There are more than apart from the percentage of reports of acceptance of reports by the executive government, I'm also trying to look at which report commended itself for acceptance and therefore executive went on to accept, and which report did not commend itself. Therefore, there is always that area where social, political, moral, other considerations. So we have an euthanasia judgment. We have judgments on related fields where court is calling upon executive to frame a law. So those are issues where a moral or an ethical consideration perhaps is hardly a rule. But certain other issues where social consideration, political. So maybe there are areas where the executive may be slow, may be reluctant, may be reticent, may have some reasons. So therefore, unless we have all those effective,
Inputs.
replying back by application of mind to certain reports, then are we not discussing in the abstract? That's what I thought. I can give a little more insights on that. And I'll also come back tomorrow on this information which your Lordship has provided
So
to me.
it's a little bit of time management. Because tomorrow we got the Jallikattu also.
Yes, yes.
So we'll allow this to spill over.
That is a Jallikattu match.
Jallikattu is also posted tomorrow.
No, I was asked to assist the court, but I have appeared in this matter with some other party.
It's coming up tomorrow.
Yes, yes.
What we can do is.
I don't think I'll take
What time
more than
will you-
I
what
don't
is the
think I'll
time
take
which
more
you-
than an hour. So
I'll take an hour.
You
so
take
let's
an
say
hour.
both.
So I'll try
to
below or I'll
try
complete
to
it.
compress it even.
Compress it
Compress.
so that, we begin our Jallikattu at 2:00 tomorrow.
I understand.
This is what,
I understand.
otherwise, it'll never get going.
We'll need a little while to rejoin because there are lots of questions that have come from your Lordship. We need to assist. We'll keep it precise.
I won't take more than 20-25 minutes in my rejoinder. 25 minutes at the
We'll also need
By
about
one-ish.
I think we-
10 minutes
If
for.
they
10 minutes
complete,
for
if the other side completes by 12:15,
12.
then
Don't even make it
By 12.
12:15. Don't give them ideas.
12.
by 12, your Lordship has said 12, we will definitely finish before 1.
Yes.
Two of us. will-
That's enough. That's enough.
20 minutes for Mr. Anup Jha.
Two, whatever you want
Yes,
to do it within that, we'll allow it up to 1:00.
Yes,
Very well.
By 2, we'll start Jallikattu.
Lord, may I point out?
I would also like to conclude because I'm chased by another constitution.
You're right. So this is what we
Needed.
did.
Election Commission may.
Very short.
Election Commission.
And you can supplement it, with written
That's
supplement. Otherwise, it'll never be over.
Please.
With my-
I-
You are supporting him or not? You are supporting?
Election Commission.
Election.
You are supporting?
No, Lords, there is some.
There is no dissonance.
No.
Filed a detailed. But that shows the sign of independence. Election Commission is not.
I'm hoping the election commission is.
With my permission.
Attorney, you are coming tomorrow. Only one question.
Yes, Your Lordship.
When we are discussing about some process in place
Yes,
in making an appointment on the post of a chief election commission,
yes.
is any procedure or mechanism in place at the moment which the government ordinarily follow while making an appointment?
Yes.
If it is there, please bring to our notice tomorrow. Or you say, no, we always use our wisdom, the best wisdom available, and then make selection, fair selection.
I don't think I will make that statement.
There is no.
With due respect to the
So we want, before we finally
Obviously, no procedure.
conclude.
No procedure.
So we want, if there is any mechanism
Exactly.
in place.
That's a welcome question and I think it was.
And,
tomorrow.
Lord,
They
but
should
with
actually-
due respect.
because they have made this
Yes,
latest
Lord.
appointment on
Yes,
Friday.
court was waiting.
It's okay.
Saturday.
Mr. Bhushan, this
They may-
question will fall upon them
What
to show
process they
what
follow.
is the mechanism they adopt.
What is the
No, but this
mechanism they
application is
adopted
still
in this
pending.
particular
Hearing
case?
is going on.
We are not on one.
The mechanism
Then-
adopted.
Then they
day
should,
before yesterday
then they
was
should
fear.
await.
That's the only
All I
mechanism
can-
adopted day before yesterday was fear.
6 months that vacancy.
Yes, my
was
lord.
Filled by you.
Please.
And suddenly after we started hearing you,
Yeah.
we see the news flash going that somebody is appointed.
Yes.
We sort of thought immediately what Prashant was saying,
That's,
that there is an interim application filed by us
Yes.
where we want that. So we thought, so we got the idea.
Mere coincidence.
That
These things happen.
that attorney will answer since this question has come and I don't want to overstep since he is directly in consultation with the government. But all I can say is my lord's Wikipedia information has given him ideas. They started from the beginning saying that so far as the process is concerned of carrying out the election, so far as the use of the power and 324(1) is concerned, we have no dispute. We are not contesting it. There is no contest on that aspect that's how they started. The statement made was this. They think it is advisable and desirable that there should be an appointment made to the CEC by an independent agency, which mechanism which is to be. Because I'll make my argument, but since the data has come from my lords today, I think they are expending the scope to say they have not questioned. And this was the beginning in the statement itself. They are not questioning the process, integrity, independence of the functioning. Though, so that was the basis of the entire premise based on which the argument started. So therefore, kindly bear this in mind. We'll meet the requirement of the data which my lords have projected to us. We'll meet that requirement, how that should be relevant or not relevant, that we leave it to the final report.
I didn't say.
But they should not move the goalpost to say that now we think there is another notification has come and subject to what information comes from the Attorney General. That should not be. Today, they should not be permitted to say that we are making a new base to say that there's a point exists based on which we can say that there is a malafide or there may be a partisan view which is being taken. That is not, should be the scope of the petition, my respect.
No, all we are saying is since they made the appointment, it must be fresh in their minds on what process they followed. They could possibly share that fine with
The
the
question has already come from the court.
The question can never be answered.
Balaji, I'll keep it for tomorrow because this has been in somewhere it's been.
When my little brother asked a question, he also knows there is no answer. He very cleverly answered.
I'm sorry, I've taken the lordship's time.
Grateful.